The court will now call the case of the state of Georgia versus Katori Davis. Case numbers 2022 WA 10030 through 10035. Present for the hearing here representing the state is Michelle Freeman. The defendant, Katori Davis, is present along with his attorney, Mr. Thomas Florio. You all may proceed.
Thank you, Your Honor. Officer Georges, you can turn your video on and unmute yourself. Would you raise your right hand, please? Do you swear and affirm that the testimony about provide in the matter of state of Georgia versus Katori Davis will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
You can lower your hand. Please tell us your name and how you're employed.
My name is Fritz Georges. I'm employed with Clayton County Police Department.
How long have you worked with the Clayton County Police Department?
Roughly about 4.5 years.
And sir, do you work with any particular unit within the Clayton County Police Department?
I was with Narcotics Division.
Were you with the Narcotics Division on June 22nd of 2022?
Yes, ma'am.
On that particular day, did the unit assist the parole department in a search at an address?
We did.
Do you recall what that address was?
No.
Was that the 41 Crystal River Road?
Yes, ma'am.
And where is that located?
In Clayton County.
Is that a house?
It's a house.
How many people were part of that search?
Mr. Davis, his sister, and the mother of his child.
And those were all the people inside of the home?
That was all the people that was taken to custody that day. And I believe juvenile minor was there as well, female.
About how many officers with narcotics unit assisted the parole department in executing this search?
It was 5 of us.
Okay. Did you make entry into the residence?
After Department of Parole did, I then came in, yes, ma'am.
Tell us how this search happened, because you said you went in after department, the parole officers went in?
Yes. Basically, they knocked on the door, and according to the DCS agent, he advised that Mr. Davis came to the door when he saw that it was Department of Parole. He retreated back into the residence, and they did not have contact with him for roughly about 5 or 10 minutes. When they finally got into the house, while searching his room, they located MDMA, a pistol box, and U.S. currency.
Just so we're clear, when you say DCS, is that the Department of Community Supervision?
Yes, ma'am. Sorry about that.
That's fine. Did you go into Mr. Davis's room as well?
No, I did not.
Who retrieved the actual items from the defendant's room?
Detective Sobajian.
Now, you indicated that MDMA was found. Was it field tested?
Yes, it was.
What was the result of that field test?
Positive for MDMA.
Do you recall how much U.S. currency was found?
I believe it was 7,000.
The handgun that was located, do you know where in Mr. Davis's room it was located?
The handgun was not located in Mr. Davis's room. It was located in his sister's room.
Did Mr. Davis indicate that that was his firearm?
He indicated that he didn't have any firearms. We Mirandized his sister and she advises that after the agents from DCS made contact, he did come into her room, and she heard him fiddling, at which there was a gun in question, a Taurus, that she had no idea about anything about. So that's where the whole firearm thing came from, was her accounts.
Did Mr. Davis, or was there a criminal history run on Mr. Davis?
Prior to us executing the search warrant, a criminal history was ran.
Was Mr. Davis a convicted felon?
Yes, he was.
The execution of this search warrant with the Department of Community Supervision, was there any specific person that was the target of this search?
No, it was just the overall residence based on the circumstances that Mr. Davis potentially might have hid further items within the house, being that the DCS agents did not have visual of him for a set amount of time that they lost visual of him.
Do you recall how the MBA was packaged?
I believe it was all bundled together in a loosely translucent bag, almost like a shopping bag that was like torn off.
Were there any other objects located in the house?
We did locate, that I recall, fentanyl as well. The fentanyl was located after the actual search warrant was executed.
Do you recall where the fentanyl was located?
It was in a bag that was in like what appeared to be a garage that was closed off to be like a game room or like entertainment area.
Was the fentanyl tested?
No.
How
Wait,
did
I'm
you?
sorry. I'm sorry. The EOD tech was out there, and they used one of their devices to confirm that it was actual fentanyl. So us ourselves, we didn't test it as we normally would other narcotics. EOD assisted us with that.
Do you recall how much fentanyl was located?
Top of my head, and I don't remember the exact amount.
This game room that you talked about, was anything else located in this room?
Ammunition, clothing that belonged to Mr. Davis, and I believe actually there was some marijuana in that room as well.
The marijuana that was located, was it over an ounce?
Yes.
Where was the marijuana located again?
It should have been in the game room that was to the right of the living room. Once you walked in the main door of the house, the kitchen sat to your left, and the game room / garage entertainment area was to the right.
How was the marijuana packaged?
I don't recall.
One of the charges was possession of marijuana with intent to distribute. Can you tell us the basis for that?
That would have been based off of the weight and the more than 2 packaging. Basically, if the marijuana and the marijuana and how it's packaged plus the weight normally would have been with intent to distribute charge.
Do you recall the actual weight and how it was packaged?
Right now, no.
Before the hearing started, did you have an opportunity to review your report?
No, I was driving and I requested it be sent so I could pull over and do it. And I haven't received it yet.
Are you able to retrieve it from your department?
The actual narcotics division would have it.
And you would not be able to review that?
And in this very moment, no.
And when you were notified of today's hearing, did you have an opportunity then to review your report?
I was notified of this hearing approximately 20 minutes ago.
So I just want to be clear. So you did not receive a subpoena, nor did someone from the district attorney's office contact you about today's hearing prior to today?
There potentially may be a subpoena in narcotics division, but I have been out of narcotics division now for, I believe, 3.5 weeks or so.
Okay. And you weren't contacted before today about the hearing?
I'm not sure, honestly.
Judge, at this time, I'm going to ask, I know if we were in person, I would be able to provide the officer with his report. He has indicated that as he was not able to retrieve the report, the only thing that I'm able to do at this point would be to screenshot the report, and I could send those screenshots to the officer as well as Attorney Florio. So Attorney Florio also has copies of that, but I would certainly ask the court to allow me to provide that to him.
Okay, we can take a short break so you can do that.
Okay, thank you.
You're welcome.
Judge, I just forwarded screenshots of what I have to Attorney Florio and Officer Georges.
All right.
Just want to make sure they received what I sent.
Yes, ma'am, Ms. Freeman. I've received them.
Okay, Officer Georges, did you receive the information?
I'm looking right now.
I just want to make sure I had your correct number.
Okay. Yes, I received it. I'm looking through them right now.
Okay, well, let me ask you this question, because I asked you several questions and you said you didn't know. And I asked the question about the charge for possession of marijuana with intent to distribute. What was the basis for that? And you indicated that you could not tell us what the packaging was or the weight. Would reviewing your police report refresh your recollection?
Yes.
Okay, Your Honor, I would ask that Officer Georges be allowed.
I'll allow him to refresh his recollection.
Thank you.
Okay.
Officer Georges,
Based
are
off
you
my,
able to answer?
yes, ma'am.
Okay, so first, what was the weight of the marijuana?
215 grams.
How was it packaged?
Let me see. I'm sorry.
Well, you indicated that the packaging and the weight would be a basis for the intent to distribute. Is that correct?
Yes, along with the scale that was found and the actual packaging material as in sandwich bags that was located as well.
Okay, you were breaking up, I know, on my end. So can you repeat that for me?
Overall, it will be the weight of the marijuana that was located, the scales were located in the area, as well as the packaging material, like the sandwich baggies as such. All that combined would have led me to charge with intent to distribute.
And those items that you said were found, the baggies and the scale, from your training and experience when you were working with narcotics unit, what are those items? What do they indicate? Officer Georges, are you still there? We can barely hear you. I just need you to turn your video on also.
Can you hear me?
We can hear you. I just need your video on.
Can you see me now?
No, we can't see you.
My video is showing that it's on.
No, we don't see you. The only thing that we see, it just says iPhone 35.
Okay, it might be the area that I'm in, but on my end, it's showing that my microphone and video are both on.
Well, it may be on, but if you have to make sure your camera is facing so we can see you.
Are you on your phone, officer? Okay, there we go. We can see you now.
Mm-hmm. Okay. Did you hear my last question?
Okay. About the intent to distribute, and based on my knowledge and experience, what would that entail of?
Yes.
Off the weight and the packaging material, that would indicate that somebody is selling marijuana.
Okay. What about the scale? What does that indicate?
Scale is also a tool that is used by people who are selling narcotics. That way they can weigh it up for the proper amount of money received for said weight.
Were the other people in the home also charged?
Yes, they were.
Did the other individuals reside at the house as well as Mr. Davis?
Yes.
You talked about some of the items. Did we lose them again?
I think so.
Okay. Officer Georges, can you hear me?
I can. Can you hear me?
Yes, we keep losing you. It must, I'm sure it's the area you're in, but and I'm almost finished. You talked about a game room that some of these items were located. Was this area, was this open to all of the residents of the home?
Yes, it was a common area. There was no locks or nothing on that area.
Did all of this happen in Clayton County?
Yes, ma'am.
Thank you. I have no further questions.
Thank you. Mr. Florio?
Yes, ma'am. Thank you. Good morning. George, is it investigator, detective? What rank are you now?
Right now, officer.
Okay. Officer Georges, good morning, sir.
Good morning.
Let me ask you, are you the highest ranking? Is this your investigation? Is this your case? Is this your investigation? Or is there someone above you that's responsible for the investigation and you were just part of writing the reports and collecting the data to that?
It became mine. It was assigned to me.
Okay. All right. And so would you agree with me that it's not often that you assist the Department of Community Supervision when they go to visit parolee?
It's something that before I left narcotics, we had started doing.
I'm sorry, Your Honor. I didn't hear the answer.
Can you repeat that, sir?
It is something that we had just started right before I left narcotics.
Okay. And so is it the sort of situation where DCS called you and said, hey, Officer Georges, we're about to go to this young man's house, Mr. Davis's house. Will you please assist us? Or did you contact DCS and tell DCS that you wanted them to go to Mr. Davis's house for a check of Mr. Davis's house?
I believe the complaint came in that the defendant was dealing in narcotics, and when we did our investigation, it showed that he was in the supervision of DCS, and we reached out to DCS.
Okay. And who made that complaint, Officer Georges?
I don't have the complaint with me. I'm not sure. Oh, no, I'm sorry. It was Crime Stoppers.
Okay. And do you know what the nature of that complaint was?
It gave a lot of information as far as his name. It gave the location. It said what he was selling. When I spoke to the defendant, he advised that he potentially thought it might have been his ex-girlfriend who was trying to harass him.
Are you familiar with whether or not there was a social media page that was presented to the Clayton County Narcotics Unit purporting to be Katori Davis's social media page?
Yes, that was also in there. Yes, sir.
Okay. And during the course of your investigation, were y'all able to either confirm or refute that in fact was Katori Davis's social media page?
I'm not sure. I wasn't involved with his social media part of the investigation.
Okay. But you'd agree with me that Clayton County Narcotics, having reviewed this purported social media page of Katori Davis, was a factor in conducting this search of his home. Is that correct, Officer Georges?
It might have been weighed into it. I didn't see his social media, so, but I would say potentially, yes, sir.
Okay. And who reached out to the Department of Community Supervision? Was it you or was it someone else?
Once I was advised that he was under their supervision, I advised my sergeant, by using my chain of command, could he reach out to somebody and see if they could assist us?
And is that Sergeant Hutchins?
Yes, sir.
Okay. And so is it your understanding or your belief that Sergeant Hutchins reached out to the Department of Community Supervision?
I would say so.
Okay. And I understood you to say that morning, what time of day was this that this occurred?
It was in the morning. I believe our meet time was 10:30. So this might have been around 11 or 12 when it finally got the search going.
Okay. And when you say your meet time, that's going to be members of the Clayton County Narcotics Unit, is that correct?
Yes, sir.
And were those officers from the Department of Community Supervision also there for that 10:30 meet time?
They came after, roughly about 15, 20 minutes after we got there.
Okay. And at some point, I understood you to say that there were two members of the Department of Community Supervision who went to the front door of the house. Is that correct?
Yes, sir.
Do you know who those officers were?
No, sir.
Okay. Was one of them Katori Davis's parole officer? Do you know that?
Yes, only because he mentioned that to Mr. Davis while we're in the house, because he had said, "I just got reassigned to you. I'm your new temporary custodian or agent."
Okay. And so I understood you to say that they at some point they made contact with Mr. Davis at the front door of the house. Is that correct?
Yes, sir.
And would you agree with me that y'all spoke with there were female occupants inside the house? Is that correct?
Yes.
Okay. And when y'all inquired as to the door not being opened as quickly as y'all would have liked, do you remember the female occupants relaying to law enforcement that it was because they weren't appropriately dressed because it was the morning hours and they had just gotten out of bed?
Yes.
Okay. And did you have any reason to think that they lied to you about that?
Yes.
Okay. Did you charge them with obstruction or false statements for having made those statements to you?
No, sir.
Okay. And so at no point was there, absent Mr. Davis opening the front door of the home, at no point was there an attempt by either narcotics or parole to breach the front door of the home, correct? Y'all didn't kick the door down or break it down or anything like that?
Not to my knowledge, no, sir.
Okay. And if y'all believed that there was the active tampering of evidence inside the home, it's reasonable to believe that you would have breached, kicked the door down, or made entry into the home to prevent the illegal tampering of evidence. Is that correct?
No, how we normally do it.
I'm sorry, sir?
No, how we normally do it.
Okay, so
this is a full search warrant.
Go ahead, I'm sorry.
Hello? Oh, unless it's an actual full search warrant, we normally wouldn't breach the door, but the DCS was up at the door first before we rolled all the way in. So we didn't know of the delay until they called us up because they actually was in the house now.
Okay. And so you understood that at some point they entered into the home, and do you believe they conducted a search of the home?
Of the home? No. Initially, when they first went in there, they went to Mr. Davis's room after he advised them which room was his. And I stood in the living room, dining room area with Mr. Davis and other occupants.
Okay. And at that point, was Mr. Davis free to leave, or was he detained?
I would believe that he was detained. I wouldn't believe that he was free to go.
Okay. And okay. Well, let me ask you, under what lawful authority had you, at that point, were you now detaining Mr. Katori Davis?
I never detained him. I stood there after DCS advised they're going to search, and for us to just stand with the individuals that was in the house.
I understand, but you've just testified that he was detained, and I'm asking you, under what lawful authority was Mr. Katori Davis detained?
It was just simply us assisting DCS while they searched. And that's what they advised us and asked us to stand.
Would you agree with me that you did not have a lawful authority to detain Mr. Katori Davis when you did? Or do you not know?
Honestly, I really don't know. I would think that we did have the grounds based off of DCS and him currently being on parole.
Okay. And so you understood those two was it both of the DCS agents that went into Mr. Davis's bedroom?
Yes, sir.
Okay. And are you familiar with an allegation that they found a grinder with marijuana residue in that bedroom?
If I check back my reports, I can see where the grinder was located, but I believe so.
Okay. And are you familiar with an allegation that they in fact found a piece of an ecstasy pill on the floor in Mr. Davis's bedroom?
A piece of ecstasy pill?
Mm-hmm.
I don't recall that.
Okay. Have you spoken with Sergeant Hutchins about this case?
No, not narcotics. No. Last time I was advised of anything about this case, we're still waiting for the reports of the DCS agents to come in so we can add to our case file.
Okay. Was Sergeant Hutchins on scene when the search was conducted, Officer Georges?
Yes, sir.
Okay. And did you talk with Sergeant Hutchins about what was located in Mr. Katori Davis's room?
I was advised what all they found in his room.
I understand, but I'm asking you, did you talk with Sergeant Hutchins about what was found in Mr. Davis's room?
Did I talk to? I asked Sergeant Hutchins questions about the whole situation and obtaining a search warrant for the residence. I don't recall talking to Sergeant Hutchins directly about what was exactly found. I know
Okay.
Detective Sobadjian came to me and advised me that he found the with DCS agents the money, MDMA, and a grinder, I believe. I think packaging material as well.
Okay. And was this close in time to when the search of Mr. Davis's bedroom had occurred?
Approximately, yeah. It wasn't a big time gap, no, sir.
Okay. And so you'd agree with me that search by Detective Sobadjian occurred prior to the issuance of a search warrant by the Magistrate Court of Clayton County, correct?
That located yes, sir.
Okay. All right. And so at some point, who was responsible for getting the search warrant?
I was.
Okay. And when the search warrant was obtained, Sobadjian had already searched Mr. Davis's bedroom, and Clayton County Narcotics Unit officers had already entered Mr. Davis's home and were located in a living room area, having already detained Mr. Davis. Is that correct?
Yes, sir.
Okay. And so at some point when y'all searched the home, was it prior to getting the search warrant or was it after getting the search warrant?
The home was never searched until the search warrant was obtained. Only Mr. Davis's room was searched by a DCS.
DCS and Detective Sobadjian, right?
Yes, sir.
Yeah, let's not forget about him. And so at some point, y'all searched the home, and I understood you to say that there was a box found in Mr. Davis's room, a gun box. Is that correct?
Yeah, like you purchase a gun and it comes in a box, which when it came out of the room, if I'm not mistaken, Mr. Davis advised that a lot of stuff in the room was there prior to him residing there.
Okay. You'd agree with me that this home was not his home. Is that correct?
I believe that was his home then because that was the address that was listed per his supervision requirements. And that was advised by him, his sister, and DCS.
Right. I'm sorry. I worded that question wrong. You'd agree with me that the owner of the home was Ms. Michaela Smith. Is that correct?
Miss Michaela Smith. If that was his sister, then
Right.
that would have been whose home it was.
Okay. All right. And you'd agree with me that Ms. Michaela Smith works in the corrections industry. Is that correct?
Yes, she advised me that after the fact. Yes, sir.
Okay. And you agree with me that as part of her career, she owns firearms. Is that correct?
Miss Laquana Howard is the sister, and that's the Michaela Smith. That's his
Girlfriend?
future baby mother. Yes, sir.
Okay, I apologize. Then Ms. Laquana Howard, you'd agree with me, works in law enforcement, or I'm sorry, the corrections industry. Is that correct?
Yes, Miss Laquana.
Okay. And you'd agree with me that you found firearms and things of that nature located in her bedroom. Is that correct?
Yes.
Okay. You'd agree with me that at no point did y'all find a firearm in Mr. Katori Davis's bedroom.
No.
Okay. And you'd agree with me you didn't find a firearm on Mr. Katori Davis's person. Is that correct?
On an actual person, no.
Okay. You'd agree with me that how many firearms did you locate, or were there located, Officer George?
I believe there were 6, including the one that Miss Howard could not account for after Mr. Davis came to her room.
And the one that she could not account for, was that gun, did it match the gun box that was located in Mr. Katori Davis's room?
No.
Okay. And so all the firearms that were located in the master bedroom in Ms. Howard's room. Is that correct?
Yes.
Okay. What proof do you have that Mr. Katori Davis knew that Ms. Howard had those firearms in her master bedroom?
If I'm not mistaken, actually, he advised that his sister had guns, that he doesn't have guns. And at that point, the DCS agent also advised him that he can't be around guns and so forth. Because they were going back and forth as the DCS agent would go back into the room or talk to him or just kind of like answer some more questions.
Okay. And so there was some dispute as to what a prior DCS agent had told Mr. Davis about his sister lawfully having guns in her bedroom. Is that correct?
I believe so. I believe they were going back and forth because they were unaware that all of this was part of his parole.
Okay. And did Ms. Howard seem to be as surprised as Mr. Davis did about the fact that she also could not have firearms in her bedroom?
She was somewhat surprised because she kept saying, if I had known that all this was part of it, I would have never agreed to, I guess, sponsoring his parole. Is that what you want to call it?
Sure. Okay. And so I also understood you to say that there was fentanyl located. Well, I'm sorry, let me take a step back. The bag of ecstasies with the several ecstasy pills that you claim were found, where were they found? In what room were they found, Officer Georges?
The fentanyl was found in the game room, and the MDMA. The MDMA was found in Katori Davis's room by Detective Sobajan.
Okay. Do you know where Detective Sobajan found the bag of MDMA?
No, that would be in his report.
Okay. The fentanyl that was found, where was that located in a game room?
The fentanyl, I just saw it. The 14 grams of fentanyl was found in the common area game room dresser found by Detective Chase.
Okay. What proof do you have that Mr. Katori Davis ever physically possessed that bag of fentanyl?
So the game room had several of his belongings that he even said was his belongings. And the fact that the game room was common access and everybody in the home had access to that area.
Okay, but let me ask you again, what proof do you have that Mr. Katori Davis physically possessed that fentanyl?
Well, I never had any proof physically. I never saw him anywhere in the house other than when I first walked in the area he was in. So I can't attest to where he's been or hasn't been in the house.
Okay. And what proof do you have that Mr. Katori Davis knew that that bag of fentanyl was located in that dresser in the game room?
I believe I told him after the fact what all we found in the house. I advised him and Miss Howard. But the whole time as I got the warrant, Mr. Davis was uttering that the narcotics in the house was his.
You're claiming that he told you, he made a statement to you that the narcotics in the house were his.
He made it randomly. I took it as just him trying to not have everybody get jammed up whatever he had going on. I didn't. Okay. I just kept walking. So
okay. So you didn't take the statement that he made to be the truth, but you took it as him trying to help the two other women that were in the house. Is that correct?
Once he advised me that he wanted to speak to an attorney, I told him that was his rights, and I kind of walked away. And he just kept making comments from the backseat of the patrol car. So I assume that's what he was trying to do.
Okay. And with regard to the marijuana, where exactly was the marijuana located, Officer Georges?
Sorry, give me 1 second. The marijuana was found, same thing, in the common area, game room by Detective Chase, the same bag where the fentanyl was located.
Okay. And let me ask you, when you talked with, just so that I make sure I understand, when you're outside the front door of the home, are you able, is there glass surrounding the front door? Can you look into the house to see what's going on inside the house?
By the time I came to the door was already open, and DCF was already in there. So I never really saw the door other than it being fully opened. Okay.
And DCS told you that Mr. Davis came to the door and then went back inside the door. Is that correct?
Yes, they made it appear to me that he made contact with them and then I believe shut the door. But we never really got the full reports from them before I left narcotics. So I wouldn't be able to testify exactly pinpointing what happened per them or their accounts.
Okay, so you're not aware as to whether or not, when you come in the front door, I understood you to say the game room would be immediately to your right. Is that correct?
When you come to the game room, it's like a little living room. You walk past that a little bit. It's a very small structure. And between the dining room and the living room, like a small little path, and then there's a door. And right there to the right, that's the little like game room, closed garage.
Okay. What proof do you have that Mr. Davis ever physically possessed the marijuana?
Proof that he physically possessed it, I don't have the proof other than everybody in the house had common access to the area.
Right. And you'd agree with me that you charged Mr. Katori Davis with possession of these drugs. Is that correct, sir?
Yes, sir.
Okay. You'd agree with me that you also made the same attestation against both Ms. LaQuanda Howard and Ms. Michaela Smith as well. Is that correct?
Yes, sir.
Okay. And so you've sworn under oath that Ms. Howard possessed the fentanyl and the marijuana and the ecstasy. Is that correct?
Yes, all occupants in the house had access to all the narcotics that was in the house. As far as the fentanyl and the marijuana, yes, sir.
Okay. And so the allegations that you've made against Mr. Katori Davis have also been made against Ms. Howard and Ms. Smith, correct?
Yes, sir.
Okay. Okay. No further questions at this time, Your Honor.
Thank you. Anything else, Ms. Freeman?
Briefly, Officer Georges, you mentioned something earlier, and I think I just didn't hear it clearly about Mr. Katori Davis making statements about the drugs. What exactly did Katori Davis state regarding the drugs that were located in the home?
As we're walking back with the search warrant, I advised Ms. Howard I had the search warrant, and he just started shouting.
Mr. Howard or Mr. Davis?
Mr. Davis. I approached Ms. Howard because it was her residence. I told her I had the warrant, but she wanted to make sure we had a warrant before searching the whole house. She just kept screaming. He just kept screaming, it's all mine, it's all mine.
Oh, I think we lost him. Well, Judge, that was going to be the only question I asked.
Judge, so, I obviously was going to have, I would have had follow-up.
So we can wait till he gets back.
Your Honor, the officer, I think, notified us that his phone died. I don't know how he's able to text us that his phone died, but evidently he's texting us that his phone has died.
He did, Your Honor. He replied to the group text where I sent he and Attorney Florio screenshots of the report, and he said the phone died. Didn't notice that the charger came out.
Okay, so
But I know, like I said, that was a question I wanted to ask and to see. I don't know if he was finished with his answer. Then Attorney Florio indicated that he wanted some follow up. So
I just texted him to see if he can log back in. I mean, if he's able to text, I don't know why he wouldn't be able to log into Zoom.
okay, we'll just hold just a few minutes to see if he comes back on.
okay.
Thank you, Your Honor.
Okay, it looks like I see Officer George is back on, so we can
Perfect,
continue
yeah.
on with the hearing.
Right. Okay. Officer Georges, and I know you don't have a lot of battery power, so and just so we're clear where I left off, my question was, what exactly did Mr. Davis state regarding what was found in the home?
He was just yelling that the drugs was his and that his family had nothing to do with it.
Did anyone force him to make those statements?
No, he made it by himself.
Did any of the other people who were being arrested, did they respond to that?
I don't recall. I don't believe no, because Ms. Howard was focused on me and the warrant, so she didn't really pay him any mind.
Did any of those other defendants make any statements regarding what was found?
Ms. Howard, after Miranda, just stated that she works and that she really doesn't know what he got going on or doesn't have going on.
Okay. That's all I have, Judge. Thank you.
Thank you. Mr. Florio?
Yes, Officer Georges, I understood you to say that Mr. Davis screamed out that that the drugs were his. Is that correct?
Yeah.
And when you say scream, you mean that he spoke in a very loud manner. Is that correct? That would be a loud, audible sound.
Yes, sir.
Okay. Were the members of the Clayton County Narcotics Unit that day, were they wearing body cam?
No.
And you testified that there were 5 members of the narcotics unit there that day, correct?
Yes, sir.
And not a single one of y'all was wearing body cam?
No, sir.
Okay. Is there any reason why you would not have been wearing body cam?
In narcotics, we don't wear body cameras.
Okay. And I would assume that who were the 5 folks that were there? You, Hutchins, and who are the other 3? Soba John?
Soba John was there, Detective Ferguson was there, and Detective Chase.
Okay. So there were no uniformed officers there, just 5 plainclothes detectives.
Officer Rowe showed up because Mr. Davis was in the back of his patrol car. So, but he never went inside the house. He just stayed on the lawn. Okay.
And so I think I understood you to say that when Mr. Davis made these statements, he was in the back of the police car. Is that correct?
Yes, sir.
Okay. And it was Officer Rowe's police car. Is that correct?
Yes, sir.
Okay. And do you know whether or not Officer Rowe had body cam that day?
He was uniform patrol, so he would have had a body cam on his person.
Okay. And since that was Officer Rowe's car and Mr. Davis was in the back of Officer Rowe's car, it's reasonable to believe that Officer Rowe would have been close by when these statements were made. Is that correct?
He might have been he should have been within 20, 30 feet if I was to guesstimate.
20 to 30 feet. Okay, great. Thank you so much. I appreciate that. No further questions, Your Honor.
Ms. Freeman?
The state rests, Your Honor.
Anything else from the defense?
No, Your Honor.
Argument?
State waives opening.
Judge, with respect to these charges, it appears that I guess there's 4 different allegations. There's going to be an allegation of firearms, ecstasy, marijuana, and fentanyl. I understand the testimony of the officer that there was ecstasy located by Detective Sobajon in Mr. Davis's bedroom. I understand for purposes of probable cause that's probably enough for the state to meet their burden. With respect, though, to the firearms and the fentanyl and the marijuana, I don't believe the state has met their burden on those charges. Obviously the officers testified as to all of those 3 substances that he has no proof that Mr. Katori Davis ever physically possessed any of those. So we're then stuck, at that point, left looking at this allegation of constructive possession and what proof there is that he constructively possessed them. And there's been no testimony that he knew that they were there, that he identified that those drugs were his, or that he identified that they were there. And what I think doesn't make sense is and I don't want to lay our defense out because I feel certain at a motion to suppress, I'm going to see Detective Georges again. But I don't think that there's been testimony presented today that he constructively possessed them. And so for those reasons, Your Honor, we would ask that those charges be dismissed. Thank you. Ms. Freeman?
Judge, of course, we're asking that all of these charges are bound over. Certainly, as Attorney Florio even pointed out, the fentanyl that was located in Mr. Davis's room, the other drugs that were located, as well as the handguns, and I can't recall if Officer Georges stated where the MDMA was found. I thought he stated that was found in Mr. Davis's room as well. If I'm wrong on that, I apologize. But I thought he said that they also found U.S. currency and a box to a handgun. So we would certainly ask, of course, that the MDMA, if it was found in his room, that would be bound over. And Judge, regarding the constructive possession, I think it's certainly at the end of the testimony when Officer Georges stated that when the arrests were taking place and Mr. Davis shouted out that it was all his, for whatever reason, whether he was trying to protect his family or he didn't want anyone else getting involved or getting in trouble for what he had done, whatever the reason may be, he did make that statement. Nobody forced him to make the statement. And so I think with that, Judge, even though the other items and handguns were found in a common room that everyone had access to, and that there was no one who could place those items in Mr. Davis's hands, but the statements where he claimed that everything found was his, I think certainly should be enough at this stage to bind all of these charges over to Superior Court.
Thank you. At this juncture, based on the evidence presented before the court today, I do find that it's sufficient to bind.
Judge, I believe that's Mr. Lowry.
Okay.
Yes, ma'am.
All right. Mr. Lowry?
Yes, ma'am.
All right, you are charged with trafficking marijuana. You have no bond set at this time. You must not violate any laws while out on bond. You have a preliminary hearing scheduled for September the 7th at 8:30 via Zoom. And Mr.
I'm sorry, Judge, could you give me that date again, please?
It's September the 7th at 8:30 via Zoom. And Mr. Morgan has indicated that you've retained him and he will be representing you. So I'm indicating that on your court-appointed attorney form that you don't need counsel. Did you have anything you wanted to say, Mr. Morgan?
Yes, Judge, if the court would consider bond, I know that Mr. Lowry's family and friends, he's from California. I know that Mr. Lowry's family and friends could make a fairly reasonable bond of say 100,000.
Yeah, I'm not allowed to entertain bond on that particular charge at this point, but that's definitely something that you could speak with the district attorney's office.
And I will try to negotiate that. Thank you.
Okay, you're welcome. All right, thank you, Mr. Lowry.
Thank you, ma'am.
All right, and are you Mr. Moore?
Yes, ma'am.
Okay, 1 second, Mr. Moore. All right, Mr. Moore, you are charged with interference with custody. Your bond is $6,000. You must not violate any laws while out on bond. At this point, you're not to have any contact with Lazarius Moore. You have a preliminary hearing scheduled for September the 7th at 8:30 via Zoom. And Mr. Morgan has indicated that he is representing you, and I've indicated that on your court-appointed sheet. You have anything you want to say, Mr. Morgan?
Just judge as to the no contact, this is his child. The child is 17 years old.
Okay.
I will state in my place as an officer of the court that the child has been back with his mother for a long period of time, well over a year. And I've talked with the mother. I don't think there's any major difficulties. Mr. Moore is actually a resident of North Carolina, so any contact that he had would be by phone. We would ask that you just limit the contact to no in-person contact unless agreed to by the mother.
Well, this is what I'll do. If the child is 17, I will just remove that particular condition.
Thank you, Your Honor. I think he turns 18, if I'm not mistaken, in October.
Okay. Okay.
So he's virtually an adult.
Right. So I don't think it's not necessary for that particular individual. Thank you for letting me know that.
Yes, Your Honor.
All right. The preliminary hearing is September 7th at 8:30 a.m. Any
Right,
questions?
Your Honor. And if he does bond out, he does waive that hearing, correct?
Correct.
Okay.
Thank you.
And we anticipate that he should be able to bond out.
Okay. All right.
Got
Good luck to you, Mr. Moore.
Thank you, Your Honor.
You're welcome.
May I be excused, Your Honor?
Yes, you may. Thank you. Have a
Thank
good
you.
day, Mr.
Thank
Morgan.
you for taking me in the order you did. I appreciate that.
Oh,
too.
you're welcome.
You're always courteous, and I appreciate that.
Oh,
Thank you.
you're welcome. Have a good day.
You too, Judge.
Okay, bye-bye.
All right, Judge, you got to start with the female.
Yes, I can do that. Why don't we do that?
All right.
All right. Are you Terrion Broad?
Yes, ma'am.
All right, Ms. Broad, your charge is driving on a suspended license. Your bond is $1,500. Knowingly driving a motor vehicle on a suspended registration, $500. Driving with no insurance, $1,000. And giving a false name, address, or date of birth, $1,500. You have a total bond of $4,500. You must not violate any laws while out on bond. You do qualify for a court-appointed attorney, ma'am, so I am going to appoint an attorney to represent you. Do you wish to waive your preliminary hearing? Or would you like to speak with your attorney first?
Speak to the attorney first, ma'am.
Okay. Your preliminary hearing is scheduled for September the 6th at 8:30 a.m. via Zoom. Thank you, ma'am.
Thank you.
You're welcome.
Dave.
Are you Lanisha Davis?
Who?
What's your name, ma'am? Are you Lanisha Davis?
Yes.
Okay. Ms. Davis, you're charged with criminal trespass. That bond is $3,000. Battery, $5,000 for a total bond of $8,000.
No.
You have special conditions to stay away from LaShonda Carter. You can't return to 5011 Highway 85. You must not violate any laws while out on bond.
I'm sorry, I
Hey,
don't know a LaShonda Carter.
I'm sorry?
I don't know a LaShonda Carter.
Okay, that's okay. Well, she's listed as the victim in your case. So just so you know, you're not supposed to be around that person. You have the option of waiving your preliminary hearing. Would you like to waive your preliminary hearing, ma'am?
No, I'm asking.
Okay. All right. I'm gonna let you talk to your attorney to determine whether you would like to do that or not. And your preliminary hearing is scheduled for September the 6th at 8:30 via Zoom. Thank you, ma'am.
I'm sorry.
What's that?
These people ain't asking me, Nick.
All right. Are you Daniqua Smith?
Yes, ma'am.
All right, Ms. Smith, you are charged with criminal damage to property in the second degree. Your bond is $6,500. You have special conditions to stay away from Branimir Briglovich. You must not violate any laws while out on bond. You have a preliminary hearing scheduled for January the 7th at 8:30 a.m. via Zoom. And I am going to appoint an attorney to represent you, ma'am.
Okay, you said January?
No, I'm sorry, September the 7th. If I say
Okay.
January, I'm sorry. It's
Okay.
September the 7th at 8:30 a.m. is your hearing, okay?
Okay.
Thank you.
All right, thank you.
You Ariana Ward?
Yeah, the clock.
Okay, I know we indicated that we were gonna do Ms. Ward's case on the paperless system, but it's not allowing me to put her bond in, so we're gonna have to revert back to the paper system for her today, okay?
Yes, Your Honor.
Okay, all right, Ms. Ward, you are charged with simple assault. The bond is $2,500. Cruelty to children in third degree, $2,000, and battery, $5,000. You have a total bond of $9,500. You must not violate any laws while out on bond. Can I ask you, Ms. Ward, how to spell Ms. Sage's first name? Do you know?
ALAINA.
ALAINA. Okay. All right. All right. So you have to stay away from Ms. Sage, Elena Sage, and you must not violate any laws while out on bond. You do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you. Do you wish to waive your preliminary hearing?
I would like to speak with my attorney first.
Okay, that's perfectly fine. Your preliminary hearing will be scheduled for September the 6th at 8:30 via Zoom. Thank you, ma'am.
Thank you.
You're welcome.
All right, Your Honor, that finishes the females.
Okay, all right. Thank you. I don't have any waivers for the females.
Thank you, ma'am.
All right. All right, what's your name, sir?
Giancarlo Allen Castro.
Okay. All right, so you're charged with interference with custody. Your bond is $4,000 on that charge, and obstruction of an officer, your bond is $2,500. You have a total bond of $6,500. You have special conditions to stay away from Jace Allen Castro. You must not violate any laws while out on bond. So you do have the option to waive your preliminary hearing. Would you like to waive your preliminary hearing?
Yes, ma'am.
Okay.
One more thing, ma'am.
Yes.
This custody case is under the jurisdiction of Harris County, Texas, in Houston. and it's already been filed for the last 2 to 3 months. We actually have a mediation date on September 15th. My daughter was living with me here for the last 3 months. She goes to school here.
Well, I don't want you to go too much into your case because I don't want you to incriminate yourself, right? And so I just, how old is your daughter?
My daughter's 8.
Okay. I'm just going to let you know, I did a stay away as a safety precaution. Talk to your attorney. That can be modified if you're concerned with not being able to see her until you resolve your case, because that's only until you resolve your case, but it can be changed sooner. But because she's so young and because of what your charge is, I put that down as a special condition, but it can be changed. So just talk to your attorney, okay?
All right. Now, is that just in Georgia or is that nationwide? Because it was that same thing was denied by the judge in Texas.
What was denied?
They filed an order for restriction.
Oh, okay. I see what you're saying. Yeah, well, that's all over. That is until you resolve your case here, you're not to have any contact with her. But it doesn't necessarily have to be that. You can talk to your attorney and they can contact our court, and it can be changed if we see fit that it's okay and we think that it's safe for her to be with you, okay?
All right. Can you remind me of that total bond, please?
Yes, your total bond is $6,500. And yeah, you didn't fill out your court-appointed attorney form. Do you have your own attorney?
Yes, I'll seek my own counsel here.
Okay.
One last question. You mentioned earlier that we can use equity, as that's the only requirement. Now, does that also include equity in a property that still has an outstanding balance, or free and clear?
Yeah, I think it does. You ask the sheriff's office, they can inform me, but I'm pretty sure as long as you have equity 3 times the bond amount, whoever it is that's going to be putting up that property, that it's okay.
Okay.
Okay. All right. Thank you.
Thank you.
You're welcome. Just 1 second, sir. All right. Are you Corey Dillard?
Yes, ma'am.
All right. Mr. Dillard, you're charged with murder, felony murder. You have no bond on that charge. Aggravated assault, no bond, and possession of a weapon or the commission of a crime, you have no bond. You have a preliminary hearing scheduled for September the 7th at 8:30 a.m. via Zoom, and a bond hearing scheduled for September the 9th. You do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you, sir. Thank you.
Thank you.
You're welcome.
Your Honor.
Are you Jabari Glover?
Yes. Yes.
All right. All right, Mr. Glover, you're charged with criminal damage to property. Your bond is $2,000. You have special conditions to stay away from 6,000 North Terminal Parkway. You must not violate any laws while out on bond. You didn't fill out your court-appointed attorney form. Do you work?
No, I'm on disability.
Okay. How much do you receive per month?
$1,000.
Okay. All right. You do qualify for a court-appointed attorney. Do you wish to waive your preliminary hearing, sir? Or you want to talk to your attorney first?
I would waive the preliminary.
Okay. Thank you.
Okay, appreciate you. Thank you, Judge.
You're welcome. Are you Derek Harris?
Yes, ma'am, I am.
All right. Mr. Harris, you're charged with obstruction of an officer. Your bond is $2,500. You must not violate any laws while out on bond. You do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you. You should waive your preliminary hearing, sir. Would you like to speak with your attorney first?
I'd like to speak to my attorney because on my paperwork, it only says obstruction. It never said anything about obstruction on an officer.
Well, that's what obstruction is, sir. You have a preliminary hearing scheduled for September the 6th at 8:30 via Zoom. Thank you.
Yeah.
Kevin.
Are you Mr. Kevin Lamar?
It's not Kevin Lamar.
Yeah. Okay, sir, you're charged with criminal trespass. Your bond is $2,000. You have special conditions to stay away from 834 Highway 138 in Jonesboro. You must not violate any laws while out on bond. You do qualify for a court-appointed attorney, so I am going to appoint one to represent you. Do you wish to waive your preliminary hearing? I'm sorry?
No, ma'am.
No? Okay. Your preliminary hearing is scheduled for September the 6th at 8:30 via Zoom. Thank you, sir.
I want to talk on my behalf, though. You hear me?
I'm sorry. What you say? What you say?
Okay, now look, check this out. I
can't talk about your case with you.
Oh, no, I don't have no ID, but I have my own apartment. So, like, for me bonding out, I have the income from Social Security, right? But even if I have the money, but I need you to kind of look out for me so I can get out, right? This could be like my good luck. You follow me? Because this is my first offense, right?
Okay, sir. Talk with the jail about bonding out, okay? All right.
I ain't got no ID.
And if you have any questions, just talk to your attorney, okay?
So I ain't gonna get an ID, right? That's my big son ID.
Good morning.
Good morning. Are you Mr. Lewis?
Yes, ma'am, I
All
am.
right, Mr. Everett Lewis, you're charged with criminal damage to property in the 2nd degree. You have no bond set at this time only because you're on probation, sir, showing that you're on probation for the city of Lovejoy. You have a preliminary hearing that's scheduled for September the 7th at 8:30 a.m. via Zoom. And you do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you, sir.
Your Honor, my probation is not religion. My probation is with Clayton County. It's not.
Okay. Okay, that's fine, but that's the reason, I'm just letting you know that's the reason why I can't give you a bond today, but it's possible that we can address it at a later date, but not today, okay?
So I can probably look forward to it on, you said the 7th?
Possibly, or even before then. Your attorney will come talk to you. He may be able to work something out before then.
Okay, thank you.
Okay, you're welcome.
How you doing, Juan?
Hi, are you Mr. Lofton?
Yes, ma'am.
Okay, Mr. Lofton, you're charged with trafficking cocaine and a tinted window violation. You have no bond set at this time on the trafficking cocaine charge, but on the tinted window, you have a $500 bond. You have special conditions that you're not to violate any laws while out on bond. You have, you do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you. You have a preliminary hearing scheduled for September the 7th at 8:30 a.m. via Zoom. Thank you, sir.
A question.
Yes.
As, like you said, with bond or something like that, you know, I know they say possession is 9/10 of the law. And so, you know, it's all I'm trying to do is get a bond so I can soften.
Okay, well, let me say this. For this particular charge, I am not allowed, I don't have the authority to issue a bond at first appearance, but that's something that your attorney can possibly arrange with the DA's office after today, okay? So talk to your attorney about that, okay?
What's the name of the attorney?
I don't know yet. You'll see him in the next few days, okay?
Okay.
Okay, thank you.
Thank you, man.
You're welcome.
How you doing, ma'am?
Hi, are you Paris Rodriguez?
Yes, ma'am.
All right, Mr. Rodriguez, you're charged with knowingly operating A motor vehicle. Hold on a second. Let me start over. I'm sorry. You're charged with giving a false name, address, and date of birth. Your bond is $500. Aggravated assault with a deadly weapon, $25,000. Fleeing from a police officer, $5,000. Possession of marijuana less than an ounce, $1,500. Driving on a learner's permit, $500. Reckless driving, $1,500. Driving on the wrong side of the road, $500. Defective equipment, $500. Activated battery, $25,000, and no insurance. You have a bond set in the amount of $60,500. You have special conditions to stay away from Sari Smith. You must not violate any laws while out on bond. You have a preliminary hearing scheduled for September the 7th at 8:30 a.m. via Zoom. And you do qualify for a court-appointed attorney, sir. So I am going to appoint an attorney to represent you.
May I get a pen to write down the amount that I need to?
You have to ask the jail. It's $60,500 is your total bond. Okay, thank you.
Thank you.
Are you Ryan Steinberg?
Yes, ma'am.
All right, so you're charged with theft by shoplifting. Your bond is $2,000 on that charge. Simple battery, $3,000, and loitering, $1,000. You have a total bond of $6,000. You have special conditions to stay away from Shalil Kotadia. You can't return to 6331 Tar Boulevard in Jonesboro. You must not violate any law while out on bond. You do qualify for a court-appointed attorney, sir, so I am going to appoint one to represent you. Do you wish to waive your preliminary hearing, or would you like to speak to your attorney first?
Speak to my attorney.
Okay, so you have a preliminary hearing scheduled for September the 6th at 8:30 a.m. via Zoom. Thank you, sir.
Brent?
All right, Everton Thompson.
Yes, ma'am.
All right, sir, you're charged with DUI, combined substances. Your bond is $5,000. You must not violate any laws while out on bond. You do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you. Would you like to waive your preliminary hearing, sir, or would you like to speak with your attorney first?
Let me speak with him first.
Okay, your preliminary hearing is scheduled for September the 6th at 8:30 a.m. via Zoom. Thank you. You're welcome.
Morning, Your Honor.
Good morning. What's your name, sir?
Robert Toohey.
Is Darrell Waits? Can you all give me Mr. Waits as well there? Since this is Mr. Toohey, I can tell them about their extraditions together.
Yes, ma'am. I'm right here.
All right, great. All right, neither one of you have charges pending against you here in Clayton County. You've been brought before the court today because you have charges pending against you in another jurisdiction, and that jurisdiction is requesting your return. As you are wanted by another jurisdiction at this time, I don't have authority to grant you a bond. So you can contest the extradition. If you contest the extradition, you will not be contesting the issue of innocence or guilt, but you would be contesting whether the extradition documents are in order on their face, whether you are charged with a crime that actually exists, whether you are in fact a fugitive from justice, or whether you are the person named in the request for extradition. Those are the only things that you could contest if you had a contest, if you contest extradition. If you decide to waive extradition, the jurisdiction that's requesting your return will have 30 days to come and get you. If they don't come and get you within that 30 days, then you will be released, okay? All right, so Mr. Toohey, the jurisdiction that's requesting your return is Tuscaloosa County. And would you like to waive or contest extradition?
I would like to waive, and can you read the charges to me?
Yes, I'll read what it says on your warrant. It says enter the offender in that said offender, being Robert Toohey, did enter and remain in the state of Georgia, knowing he is wanted by Tuscaloosa County Sheriff's Office for driving under the influence. They will extradite.
All right, well, I did not know I had that charge, so I wonder if I did not know I had a charge.
Well, if you're waived, they'll take you back and you can take care of it. Okay. All right. Thank you. All right, Mr. Waits, the jurisdiction that's requesting your return is Hopkins County, Texas.
Yes,
Looks
ma'am.
like it's for a probation violation. Would you like to waive or contest your extradition?
I'll wait, right, wait.
Okay. All right. Thank you, sir. Have a good day. All right. Are you Terrence Williams?
Yes, ma'am.
All right, Mr. Williams, you're charged with possession of marijuana less than an ounce and use of possession of drug-related objects. For both charges, it's $1,500 apiece for a total bond of $3,000. You must not violate any laws while out on bond. You do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you. Do you wish to waive your preliminary hearing?
No.
Okay. Your preliminary hearing is going to be on September the 6th at 8:30 a.m. via Zoom. Thank you, sir.
Yeah, all the way down, right?
Are you Willie Williams?
Yes, ma'am.
All right, Mr. Williams, you're charged with unlawful baggage removal. Your bond is $6,000 and possession of marijuana less than an ounce, $1,500. Your total bond is $7,500. You must not violate any laws while out on bond. You have a preliminary hearing scheduled for September the 7th at 8:30 a.m. via Zoom, and you do qualify for a court-appointed attorney, sir. Thank you.
All right, Judge, that's gonna be everyone for today.
Let me ask you, do you all have any Elijah D on your calendar? I didn't have, I have paperwork for him, but I didn't see him listed.
Yes, man, Elijah D, he bonded out.
Oh, he bonded out. Okay, good. All right, thank you. And oh, let me just check with you.
All right, today is August 24th, 2022. I'm Judge Case Johnson. This is the matter of Ricardo, State of Georgia versus Ricardo Jonathan Ward, charged in warrant number 2022 CW 51432, possession of a firearm or dangerous weapon. 2022 CW 51433, participation in criminal gang activity. 2022 CW 51434, another participation in criminal gang activity. 2022 CW 51435, BGCSA. 2022 CW 51436, possession of a weapon during the commission of a crime. And 2022 CW 51437, possession of machete gun or sawed-off shotgun. Representing the state is Ms. Jocelyn Watkins. Representing the defendant is Mr. Stanley Schoolcraft. Ms. Watkins, you're a witness.
Thank you, Judge. Good afternoon, officer. Please raise your right hand. Do you swear or affirm that the testimony you'll give today in this proceeding before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Hold your hand and please introduce yourself to the court and opposing counsel.
Detective Chase from Clayton County Police Department.
And Detective Chase, how long have you been so employed with the Clayton County Police Department?
Approximately 4.5 years.
And what are your current duties with the Clayton County Police Department?
I am a detective assigned to the Narcotics Division.
And what are your responsibilities as a detective in the Narcotics Division?
Currently, I'm assigned with investigating narcotics-related violations as well as violations of the Criminal Street Gang and Terrorism Act.
And how long have you been so assigned to this unit?
Approximately 1.5 to 2 years.
And have you had any specialized training for your involvement in the narcotics unit and the gang work that you do?
Yes, I have.
Can you explain that to the court and opposing counsel?
I have attended the GGIA's basic gang investigators course, as well as Gypstick's gang recognition and identification course, as well as the Gypstick gang investigation and prosecution course.
Thank you. And has that training, is that training used in your work as a part of a detective in the narcotics division and your gang cases with the Clayton County Police Department?
Yes.
Prior to joining your current division, what were you doing with the Clayton County Police Department?
Prior to that, I was assigned to uniform patrol as an officer.
And in your work on uniform patrol, what would you do?
I would respond to calls for service and calls for assistance from other officers.
And did any of those calls ever involve narcotics and or gang activity?
Yes.
And cumulatively, Detective Chase, about how many cases would you say you've been involved with involving narcotics?
I would say over 50.
And how many cases would you say you've been involved with involving gang activity?
I would say mid-20s to 30s.
Thank you. I want to direct your attention to February 16th, 2022. Were you working with the Clayton County Police Department at that time?
Yes, I was.
And were you working in a post-certified capacity?
Yes, I was.
And were you working in your current division of narcotics and gangs?
Yes.
Do you become involved with a case and were you involved with a case involving defendant Ricardo Ward?
Yes.
Can you explain to the court what your involvement was in that case?
In the case involving Mr. Ward, the uniform patrol conducted a general patrol in which they observed 5 males inside of a vehicle. During the course of the investigation, probable cause was established and the officer was able to search the vehicle. Upon searching the vehicle, numerous firearms and a felonious amount of marijuana was recovered at that time. And at the conclusion of the investigation, that officer handed the case off to the narcotics division based on the amount of narcotics that were recovered, as well as the firearms that were recovered from the scene at that time.
Thank you, Officer Chase. Specifically, was that patrol being conducted at 330 Arrowhead Boulevard in Jonesboro, Georgia?
Yes.
And is that here in Clayton County?
Yes.
And when you say an officer was on patrol and saw multiple individuals, was the defendant in this case one of those individuals?
Yes.
And when you say that contact was, probable cause was established to search a vehicle, is that vehicle, was the defendant involved with that vehicle?
Yes, sir. But yes, based on the officer's testimony, the defendant was observed to be inside the vehicle.
And when the officer made contact with the defendant and the other individuals, did he make any observations of that vehicle?
Yes, when he arrived on scene, he smelled the odor of marijuana emanating from inside the vehicle. Once the male subjects observed the officer, 2 of them took flight away from the scene, and the other 3 individuals that remained on scene attempted to walk inside one of the apartments at 330 Arrowhead.
And was defendant Ward one of those individuals that took flight, or was he one of the individuals that stayed on scene?
He remained on scene.
And was the officer able to make contact with Defendant Ward specifically?
Yes.
And was Defendant Ward or were any of the individuals able to provide any information about the vehicle that they were just in?
At the time of the investigation, no. The offenders, all of the three individuals that remained on scene, they all claimed no responsibility for the vehicle or anything that was inside it.
And was the owner of the vehicle at some point contacted?
Yes.
And what happened based on that contact or communication with the owner of the vehicle?
The owner of the vehicle was able to identify the driver of the vehicle who had fled from the scene on foot, as well as give officers access to the interior of the vehicle by a spare key that he provided once he arrived on scene.
And that driver of the vehicle that had fled on foot, what was his relation to the owner?
The driver of the vehicle was the son of the owner of the vehicle.
And so ultimately, did law enforcement conduct a search of that vehicle?
Yes.
And can you tell the court what items were located inside that vehicle?
Approximately 45 grams of marijuana, 2 Glock handguns with modifications to them that made them fully automatic, as well as an additional handgun and an AR pistol.
Detective, 45 grams of marijuana, is that more or less than an ounce?
That's more.
And do you know approximately how many grams of marijuana makes an ounce?
Approximately 28.
Detective Chase, I'm not sure if it broke up for everyone, but that part of your testimony came through a little bit unclear. Would you repeat your answer?
I'm
Your Honor, is the court experiencing the same technical difficulties? Okay.
I am as well.
Okay, thank you, Attorney Schoolcraft. Detective Chase, do we have you back?
Yes.
Okay, thank you. Could you go ahead and answer that for us one more time?
Approximately 28.
Thank you. With respect to the firearms that were located in the vehicle, you mentioned that there were some modifications made. Can you explain that to the court?
There were two. The best way to describe them are small plastic squares attached to the back plate of a Glock, which essentially turns the Glocks into a machine gun.
And is that a lawful or authorized modification to that firearm?
It is unlawful.
Detective Chase, you mentioned also that you have, in addition to your narcotics work, gang training, or you do gang investigations with the Clayton County Police Department. Did any of that training or knowledge or skills become relevant in this investigation?
Yes, it did.
Can you explain to the court that relationship between that training and how that relates to this case?
Some of Mr. Ward's co-defendants had previously been identified by the Clayton County Police Department's gang unit as gang members prior to this incident. During the course of this investigation, several Instagram accounts which belong to Mr. Ward, as well as the co-defendants, were subject to search warrants, and based on the data that was gathered from those accounts, we observed Mr. Ward, as well as all of his other co-defendants, using sign symbols, clothing, and indicators that they all participated in a criminal street gang.
And Detective, For further clarification, can you describe what criminal street gang that is and what kinds of clothing or symbols or things of that nature would lead you to believe that there was a connection between this defendant and a criminal street gang?
The specific criminal street gang would be the Bloods. Some of the co-defendants represent a different subset of the Bloods, but they are all a part of the Bloods criminal street gang. They all share the same common traits as wearing red clothes, throwing up the B hand sign, using coded gang language specific to the Bloods criminal street gang when posting on social media or when speaking to each other.
Thank you. And those general indications of gang activity or gang involvement or affiliation, did you find those indications in this case with respect to Mr. Ward and any of the other co-defendants?
Yes.
Thank you, Officer Chase, Detective Chase. I apologize. Nothing further, Your Honor.
All righty, Mrs. Schoolcraft?
Yes, Judge. Just a few questions. First of all, you didn't do the search of the car, right?
No, sir, I did not.
Who did the search of the car?
Officer Christian as well as Officer Garcia.
Okay, was the car stopped or did they stop it for a traffic violation?
The car was parked in front of apartment 48 at 330 Arrowhead.
Okay, so the car was parked, the police approached it. I mean, do you know what happened?
Yes, sir. So based on Officer Christian's report, as well as a testimony that he shared with me, upon his entrance into the apartment complex, he conducted a general patrol. At the time, he observed all 5 of the offenders in reference to this case inside of that vehicle that was parked outside of apartment 48. Upon seeing him, the driver and the front passenger of that vehicle fled on foot, and the other 3 gentlemen exited the vehicle and attempted to walk inside of one of the apartments.
But they didn't, Mr. Ward was one of the 3 that attempted to walk inside the apartments?
Yes.
Okay. And what probable cause did the police have to even approach the car?
So Officer Christian was conducting a general patrol and he observed
what?
Uniformed he observed the individuals take flight upon seeing a uniformed officer, which gave him a to believe that a crime was either about to be committed or had been committed.
Okay.
At that point, he detained Ward as well as 2 of the other individuals that were about to try to enter the apartment.
What probable cause did he have to detain Mr. Ward? What evidence did he have that Mr. Ward may have committed a crime? Because he got out of the car?
So to be clear, when the individuals inside of the car saw a uniformed officer, the driver and the front passenger took flight. Their flight upon seeing a uniformed patrol officer indicated reasonable suspicion to Officer Christian that a crime may have been committed in that vicinity. Officer Christian then, with the reasonable articulable suspicion, detained Mr. Ward and the other 2 individuals in an attempt to dispel his suspicion. However, upon doing so, Officer Christian smelled the odor of marijuana emanating from the inside of the vehicle as he walked past it and attempted to conduct his investigation.
And where in the car were the drugs found?
The drugs, they were found in the rear passenger seat.
Where, left side, right side?
I'm not sure of the specifics, but I am aware that it was found in the rear of the vehicle.
Okay. And the guns, where were they found?
The guns, they were found, I can't tell you specifically where each gun was found inside the vehicle, but I do know that all the firearms were located on the interior of the vehicle.
Do you have any evidence at all that Mr. Ward possessed any of these guns at any particular point in time, except for the fact that he was sitting in the car where they were sitting?
So when you say possession, what do you mean?
I am asking you, do you have any evidence at all that Mr. Ward possessed these guns at any particular point in time, other than the fact that he was sitting in the car?
So his being in the vehicle, as well as everyone's denial of any possessions of any of the illegal contraband that was found inside the vehicle, is enough for me to articulate his legal possession.
Okay, but you arrested him anyway, or this officer Christian, correct, arrested him. I'm just trying to make clear what's going on. Okay, who arrested Mr. Ward?
I believe Mr. Ward was arrested by the Clayton County Sheriff's Office.
On the scene?
No, sir, he was not. He was not arrested on the scene that day.
Okay, so let's see if I've got this right. The police approach a car and 2 people flee. 3 people get out of the car and walk toward the apartment. Have I got it right so far? And
Yes,
Mr.
sir.
Ward is one of the 3 people. He didn't run from the police. He just walked toward an apartment. Did they ever determine whether or not he lived in that apartment complex?
No, sir.
Okay. So he could have been going home for all you know, or all Officer Christian knew. He could have just been walking home. True?
He could have, yes, sir.
Okay. Now, he was not arrested on the scene that night, but he was detained for a few minutes when he said, "I don't have anything to do with anything you find in that car."
Yes, sir.
Okay. Now, but he was arrested at a later date, is that it?
Yes, sir.
Okay. And why at a later date? In other words, what changed from that night to when he was arrested? Caused him to be arrested?
To the altered firearms that they found, which so based on the amount of marijuana that was found in the vehicle, as well as the alterations to the investigation was handed off to the narcotics division. And once it was assigned to me and I was able to gather all the relevant facts, arrest warrants were taken out thereafter.
Okay, so no one was arrested on the scene then?
No, sir.
Okay. So, and you said that you had a search warrant for my client's social media, true?
Yes, sir.
And what probable cause did you have to get that search warrant? Because he was in a car?
Yes, sir, because he was in legal
relevance
of contraband.
Okay.
Okay, hold on, Ms. Watkins, you have an objection?
Yes, Judge, objection relevance. We're here to determine, establish the probable cause for arrest on these offenses, not to argue a motion to suppress based on the search warrant for the social media account of this defendant and or other defendants.
Judge, the reason I apologize. The reason I'm going into this is because he is here on probable cause that he committed these crimes. He wasn't even arrested that night. So I'm entitled to go into some of these things. I'm not trying to lay groundwork for a motion to suppress or anything else. I'm trying to figure out what happened between that time when they didn't have probable cause to arrest him until later on when they did have probable cause.
All right, you may continue, Mr. Schoolcraft.
Thank you, Judge. Okay.
Again, sir, to be clear.
Oh, Officer Chase, your
probable cause exists.
We can't hear you.
That night.
Officer Chase, we cannot hear you.
Yes. Can you hear me now?
Yes.
Now, officer, can you hear me okay? Or detective, can you hear me okay? Yes, can you hear me okay?
Yes.
Okay.
Probable cause existed
Go ahead.
that The only reason that they weren't taken into custody was based on the amount of drugs they found and the modifications to the firearms, which indicated to the uniformed patrol officers that a deeper level of investigation needed to be done, which they weren't capable of doing at that time.
You said that you had social media of Mr. Ward doing gang signs and wearing red shirts. True?
Yes, sir.
Okay. It's not against the law to belong to a gang, is it?
No, sir, it is not.
Okay. So I can wear red shirts and make all the gang signs I want, pretending like I'm in a gang. But that's not what we're here for, right?
So we are here for the participation in criminal gang activity, which, if I heard correctly, is one of the numerous charges that Mr. Ward is here for today. So it is not illegal to be in a gang, but to participate in criminal gang activity, which he was charged with, is in fact illegal.
Except that you didn't have probable cause to say he participated in anything that night. But a few days later, after you found out that he might belong to a gang, that's when you had probable cause, right?
Probable cause for the gang charges?
For all of the charges.
No, sir. So the probable cause for the participation in criminal street gang activity, yes. The probable cause for the firearm possession and the drug possession existed that night.
Okay. But you didn't arrest him, even though the guns were altered.
No, sir.
And the officer knew they were altered that night, right? True?
Yes, sir.
Okay,
but
so
the uniformed patrol officers do not have the, yes, sir, but the,
now again, the officer, I believe it was Officer Christian, he didn't say where everybody was sitting in the car, didn't say whether or not any person had in his possession the drugs or the guns. True? Actual possession.
That is not true. Officer Christian identified the driver and the front right passenger, as well as the three individuals that were sitting in the back of the vehicle, which Mr. Ward was one of them.
But he didn't see any of them with actual possession of those weapons. Is that not true?
He saw them exiting the vehicle, which the weapons and marijuana was found inside of.
Officer, that wasn't my question, or detective. My question was, did he ever see Mr. Ward in actual possession of any of those items in that car? Did you hear the question?
To be specific, yes, sir. To be specific, are you asking if Officer Christian saw Mr. Ward holding a firearm or marijuana that
Was
day?
he in actual possession of guns or marijuana that the officer saw?
Yes, sir, he was.
Why? Because he was sitting in the car? Is that what you're calling
Yes,
actual
sir.
possession?
So it constitutes constructive possession.
Okay. So basically, the gang charges are based on constructive possession of my client by my client in a car that he was not driving, did not own. That's what you're saying.
Yes, sir.
And can you tell me the sawed-off shotgun, which one was that?
So that is just the way the code section is written. That code section is specific to alterations, illegal alterations made to firearms, which machine gun possession, which the Glock would classify as based on the state statute, falls under that charge.
Okay. Now, the last question is, where's the connection between the gang and those guns? In other words, As you're well aware, gang charges, in order to be valid, is there has to be a nexus between the crime itself and the gang. Now, have you established any kind of a nexus between the possession of those guns and some kind of gang activity?
Yes, sir.
And which is what?
Which is the possession of those guns were posted on social media in a way to further the interests of the gang, being that the gang members, those individuals that were also charged under this case with Mr. Ward, all have numerous pictures with those firearms on social media in a way to indicate that the gang and its members are responsible for the possession.
The question is, you mentioned the term furtherance of the gang. What was the furtherance of the gang holding those guns? Even in the
So
social
one of the ways that the nexus is satisfied is if a crime is committed by a gang in order to maintain or reestablish that gang's reputation. The way that gang members do that is posting videos and pictures of themselves holding firearms on social media.
Do you have pictures or videos of any kind with Mr. Ward holding any of these firearms? I'm not asking about his co-defendants now, I'm just asking about him.
Yes, sir.
You do?
Yes, sir.
Okay, how many times?
Yes, sir. I can't
Was it
specify, sir.
1, 21? Was it a lot or a little?
Again, I can't specify.
So he could have been in a picture with one of his co-defendants who was holding the gun, and you would put him in there, right?
I'm sorry, can you repeat the question?
He could be in a picture, a video, or social media with one of his co-defendants, his co-defendant holding the gun, and you would attribute that to him as well. It's not true.
It depends on the context of the picture.
Your Honor, that's all I have.
All righty. Any redirect, Ms. Watkins?
Judge, Detective Chase, going back to the vehicle that the defendant was seen in initially and seen exiting by Officer Christian, did you testify earlier that y'all spoke to the owner of that vehicle?
Yes.
And what was the owner's response regarding the marijuana in that vehicle? Was it his or hers?
No, ma'am. The owner only indicated to the officers that day that he gave his son, which was the driver that fled from the scene, possession of the vehicle earlier that day, and none of the marijuana or firearms belonged to the owner.
And so the marijuana did not belong to the owner. What about the firearms?
No, ma'am.
Speaking of the owner's son, is he one of the individuals that was also identified as being a member in the same criminal street gang as the defendant?
Yes.
And is he also, what did your investigation uncover regarding his social media pictures, posts, videos, or anything of that nature?
Objection, Your Honor. This is Mr. Ward's hearing, not his co-defendant. Doesn't make any difference what the investigation.
Just restate, Ms. Watkins.
Thank you, Judge. Detective Chase, did your investigation uncover that there was any social media posting or involvement with gang activity regarding the defendant and any of the co-defendants?
Yes.
Detective, you mentioned earlier when
yes,
you were,
ma'am.
Can you hear me, Detective Chase?
Yes, I can.
I want to direct your attention back to a separate line of your testimony and questioning by opposing counsel. You mentioned that the officers, Officer Christian specifically, was doing a general patrol of the area. Do you remember that line of questioning?
Yes.
And To the best of your knowledge, did he have to have a reason to go up and talk to the individuals with respect to that vehicle?
With respect to that vehicle, yes. One of the individuals that was inside of that vehicle had been being monitored by the Clayton County Police Department gang unit prior to this incident occurring. Officer Christian observed that individual brandishing a firearm and in possession of marijuana prior to Officer Christian conducting the general patrol of that area.
And on the date at issue, Detective, when Officer Christian made his observation of the defendants in that vehicle, was the individual that had been previously being monitored a part of the group of individuals at the vehicle along with the defendant, Mr. Ward?
Yes.
Detective, I want to talk to you a little bit specifically about gangs and gangs here in Georgia. You were questioned by opposing counsel about if just wearing red and things of that nature would make somebody a member of a gang. Do you recall that line of questioning?
Yes.
Is there or are there things that law enforcement looks for to determine involvement with a gang?
Yes.
Okay, and before you explain to me what those are, Detective, what levels of involvement with a gang can a person have?
One can be a member, one can be an associate. It is widely dependent on the gang and their bylaws.
Okay, and with respect to the things that law enforcement or that you specifically are looking for when you're conducting your investigations, what are you looking for to determine if a person is a member or an associate of a gang?
The things that I specifically look for are common customs, courtesies, and traditions that are traditionally associated with whichever gang it is, as well as any continued involvement with other gang members or suspected associates, and the participation in any of the enumerated offenses that would fall under the Criminal Street Gang and Terrorism Act.
Okay. Now, opposing counsel mentioned that in the state of Georgia, it's not illegal to be a member in a gang. Is that accurate?
Yes, that is accurate.
Okay. But you were responding saying that it is illegal to do activities in furtherance of the gang. Do you recall that testimony?
Yes.
Okay. Does a person have to be a member to do activities in furtherance of a gang, or?
No, they could merely be an associate.
Okay. And when you talked about actions or activities in furtherance of a gang, can you please re-explain what you were stating with respect to what constitutes actions or activities in furtherance of a gang?
Anything that would further promote the gang's violent nature or maintain or reestablishes that gang's reputation to the public, whether it be actually in person or them posting incidents that the gang is responsible for on social media.
Okay. And Detective, when we talk about maintaining or establishing reputation, and you make mention of social media, what, based on your training and experience, do you know to be activities commonly associated with this specific gang that would be in furtherance of gang activity?
Specifically, their possession of marijuana, which is commonly used as a way that the gangs attain funds to either continue to purchase more drugs that they can flip or more firearms. Blood gang members specifically are notoriously violent, and they commonly share images, videos, and document their firearm possession on social media as a way to generally intimidate and terrorize the general public and reaffirm their reputation as violent members of the blood gang.
And in this case specifically, And with respect to defendant Ward specifically, did your investigation reveal social media content in line with what you just testified to?
Yes.
And can you describe what social media content with respect to defendant Ward your investigation uncovered?
There were numerous videos that included Mr. Ward as well as the co-defendants brandishing firearms. There are videos of his co-defendants discharging the automatic firearms, as well as conversations about the firearms and the felonious drug possession.
And again, those are with respect to defendant Ward specifically. Is that correct, Detective?
Yes.
Lastly, I want to talk to you about these firearms. Are these firearms that were, or the firearms that were located in the vehicle, the same firearms that you also saw on these social media posts that you were just referencing?
Yes.
Okay. And with respect to those firearms, you mentioned earlier that there was a modification and something about a little square, making it mostly more so an automatic weapon. Can you explain that in further detail?
There is a part of the code section that Mr. Ward was charged with that indicates that if a weapon's trigger is pulled one time and it fires, it discharges more than 6 rounds per one trigger pull, then it is legally classified as a machine gun. And two of the firearms, 2 of the Glocks with the switches, they were both test fired at the Clayton County Police Range, and they both, per one trigger pull, both weapons discharged at least 6 rounds automatically.
Okay. And is that modification, again, a legal modification?
No, it is not.
And does that modification in turn take that handgun and turn it into a machine gun as listed in that code section?
Yes, it does.
Thank you, Detective. Nothing further, Your Honor.
All right, Mr. Schoolcraft, you have any
Nothing else, Judge.
closing arguments? Ms. Watkins?
Just state with reserve.
All right, Mr. Schoolcraft.
Yes, Judge. As the court well knows, the law is well established that possession in an automobile, unless actual possession by any of the passengers in the vehicle, that possession of whatever is in the vehicle is presumed to be the driver or the owner. In this case, the owner's son was the driver. So that the law presumes that everything in that car is in the possession of the driver, not the passengers. That law is rebuttable, or that presumption is rebuttable, but only by the driver, not by the police. The officer testified that Mr. Ward, that there was no evidence that Mr. Ward ever actually possessed those weapons. So I go back to the driver constructively possesses all those weapons, not the people in the car, but the driver. My client did not run when the police came up. As for the gang charges, apparently there's video showing he's a member of a gang, but the officer, especially in his last part of his testimony, specifically said that it was his co-defendants that were holding the guns and discharging them, not Mr. Ward. And again, it's not illegal to be a member of a gang. I'm not saying it's a good thing, it's just not illegal. And there's no proof on the record that was just made that Mr. Ward ever did anything to further the gang activity, further anything having to do with the gang. There may be evidence, as testified, that he belongs to the gang, but we don't know whether he's an associate member or whether he just plays along with them. Don't really know. But I do know that the guns, as the officer testified, were in the possession of the co-defendants, not Mr. Ward. And again, I go back to the other one. This whole thing stems from being in the car. Judge, the other thing too is that this would appear to be a tier 1 encounter. Tier 1 encounter, anybody can leave a Tier 1 encounter at any time they want. The police don't have a right to just question somebody because they got out of a car. And they obviously didn't have enough that night, or else they would have arrested Mr. Ward then. So my argument to the court is I believe that all the charges should be dismissed because there's no proof that my client ever possessed those guns or the drugs. The driver, yes, because that's the presumption by law. And that he ever did anything to further gang activity. Sitting in a car with weapons. In fact, the police officer didn't even testify as to where the guns or the marijuana were found. Were they underneath the seats to where they weren't in plain view? So if my client got in the car, he wouldn't even know they were there. There's no evidence implicating my client as ever possessing the drugs or the guns. And then all the other charges would fall, because if he didn't possess it, he certainly couldn't have participated in gang activity. Thank you, Judge.
All right, Ms. Watkins, go ahead.
Thank you, Judge. Brief recap of the testimony as it was elicited and brought before the court through Detective Chase is that there was an outstanding investigation or an ongoing investigation of one of the other co-defendants that is involved in this incident with this defendant, Mr. Ward. And that on the date and issue, in this case, February 16th of 2022, Officer Christian of the Clayton County Police Department was on general patrol of an apartment complex where he had seen that known gang member and person of police interest in possession of marijuana and the firearms that were ultimately located in the vehicle that the defendant was associated with. And so based on the known involvement of that other individual and the investigation that law enforcement had going on while they were on general patrol, law enforcement observed the defendant along with 4 other individuals inside this automobile. And while they were inside this automobile, it's presumed that the 2 individuals who fled on foot saw law enforcement and fled on foot, one of those being the driver and the son of the owner of that automobile, the other being the front seat passenger. And the 3 rear seat passengers, this defendant, Mr. Ward, along with 2 other defendants, exited the vehicle and attempted to walk away from that vehicle into a residence in a nearby apartment unit in Building 48. And in doing so, that alerted Officer Christian that there may be a crime afoot, that maybe a crime had occurred or was in the process of occurring based on the knowledge that he had about one of the individuals who was present in that vehicle and having seen that person in possession of marijuana and a firearm. And so Officer Christian made contact based on his observations with this defendant, Mr. Ward, along with the 2 other individuals. And in doing so, was able to observe the odor of marijuana emanating from the vehicle. And Judge, this isn't one of those cases where there's the smell of marijuana and no marijuana is found. In fact, 45 grams of marijuana was found inside that vehicle, along with numerous firearms, 2 of which were modified in such a manner as testified by Detective Chase that made them illegal in the sense that they were illegally modified and became machine guns. And so it was that occurrence of events that led to the detention of this defendant, Mr. Ward, and the further investigation of law enforcement to determine, hey, I can see that something's been changed with this gun, but let's figure out what's actually going on. And so Attorney Schoolcraft repeatedly questioned Detective Chase that, oh, well, you didn't have PC to arrest at that time. You didn't have probable cause to arrest. And Detective Chase repeatedly stated, no, there was in fact probable cause to arrest at that time. But in addition to what the officers were able to see, which was that there was 45 grams of marijuana, which is a felony possession amount of marijuana, there were firearms in the vehicle, which is a felony in and of itself, possession of a firearm during the commission of a felony. There was inquiry as to the modification of the firearms to determine whether that was a legitimate modification. And so those firearms were taken and discharged at the Clayton County Police Department's firing range and determined that they were not lawful modifications. In fact, Detective Chase further clarified that it was illegal because that modification allowed for more than 6 rounds of ammunition to be discharged per one pull of the trigger, making it a machine gun. And so that testimony was unrefuted, unimpeached. There was nothing about that testimony that came out as hindered. And so the firearms and the marijuana were in fact determined to be illegal in those manners. With respect to the possession of the firearm and marijuana, Judge, constructive possession is an acceptable form of possession. And in this case, it's not just constructive in the sense that the defendant was in the back car of a vehicle where marijuana and firearms were found in the back car of that same vehicle, but in fact, the defendant was seen on social media posting videos with these same firearms. And so the defendant was in fact in possession of these firearms, and the social media accounts and the social media investigation showed not only that he had actual possession of these firearms, but that he had actual possession for a purpose. And that purpose was for the furtherance of the criminal street gang, the Bloods specifically in this instance, in that the defendant, whether the state proves that he was a member or an associate, whether if he was a member, was doing it in furtherance of his specific gang, or if he was an associate, was associated with known members of that gang. In either instance, Judge, OCGA 16-15-4, participation in a criminal street gang prohibited, states that it's unlawful for a person to be employed by or associated with. So a mere association with the street gang in furtherance for offenses later enumerated, will be an unacceptable involvement with a gang. And so while being a member of a gang in and of itself might not be illegal, participation in gang activity is illegal. And so the question of whether or not there was participation in gang activity in this case is boiled down to what was observed via the social media accounts of this defendant and the co-defendants, in which they were in possession of the firearms and showing them off, as Detective Chase testified, is customary of this particular street gang, and for the purpose testified specifically to maintain or establish their reputation. And that's a reputation known for the Bloods as being a violent street gang, as indicated by handguns that had been so modified to be machine guns and discharge multiple rounds per single pull, as well as a gang known for possession of marijuana specifically. And that marijuana could be for consumption, it could be for sale, to increase funds, or sale to increase funds that are later turned to get additional firearms or additional narcotics, again, as testified by Detective Chase. And that testimony went unimpeached, Judge. There was extensive questioning about, well, whether there was probable cause for the search warrants or probable cause for the initial encounter or probable cause. At the end of the day, Judge, none of the detectives' testimony, while it came through a little bit broken at times, the reception was a little unclear. When it was clear and the questions were re-asked, the detective testified that this defendant specifically was seen with these specific firearms on his social media, and that there was a reason why the defendant was not arrested on the date where he was seen in possession of the marijuana and firearms in the backseat of the car. It was for further investigation. And while that further investigation was just to determine the extent of the modifications of those firearms, it also uncovered that this defendant is involved in an illegal manner with the criminal street gangs, the Bloods. And so, Judge, looking at charges, specifically the charges regarding the machine gun or sawed-off rifle, that warrant for possession of a firearm during the commission of a crime is the state has proven that there is probable cause for that. With respect to possession of the firearm during the commission or attempted commission of felonies. The state has proven that there was possession of those firearms during the commission of certain felonies, both VGCSA felonies and violations of the Georgia Criminal Street Gang Act. Additionally, Judge, there was possession of 45 grams of marijuana, which is over an ounce of marijuana. There was and there were violations of the criminal street gang as required. And Judge, again, it's not illegal just to be a member of a criminal street gang, but 16-15-3 further enumerates those activities for which it would be illegal to be a member of the street gang, of which possessions of firearms, and narcotics are associated, Judge. And so the state would put forward that we've proven that there was probable cause for these specific arrests with respect to this specific defendant, Mr. Ward, and ask that all charges be bound over to Superior Court.
All right, Ms. Watkins, Mr. Schoolcraft, based upon the evidence presented, I do find that there is sufficient probable cause to bind all his charges over Superior Court of Clayton County. That's the order of the court.
Thank you, Judge. May I be excused?
Absolutely. Thank you, Mr. Schoolcraft, for logging on.
Thank you, Judge, and may Detective Chase be excused.
Yes, thank you, Detective Chase.
Hey, Judge, we're still live on YouTube.
And sir, are you Nora Harris?
Yes, ma'am.
Okay. All righty.
Good morning. Good morning. Good morning.
Good morning. Hold on, we are still trying to go live. All right. Today is August 24th, 2022. I am Judge James Johnson. This is the matter of State of Georgia versus Nora Harris, warrant 2022 CW 53188, charged with possession of a firearm by a felon or first offender probationer. Representing the state is Ms. Jocelyn Watkins. Representing the defendants, Mr. Jabbar Rogers. Your witness, Ms. Watkins.
Thank you, Judge. Good morning, officer. Please raise your right hand. Do you swear or affirm that the testimony you'll give today before this court in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please introduce yourself to the court and opposing counsel.
My name is Officer Whitworth. I work for Clayton County Police Department.
And Officer Whitworth, how long have you been employed with the Clayton County Police Department?
A little over 2 years.
And what are your duties with the Clayton County Police Department?
I'm a police officer on the road.
And does that involve you responding to calls for assistance?
Yes, ma'am.
And approximately how many calls have you responded to during your 2 years of employment?
I don't know the actual amount, but I would say over 100 calls.
And are you post-certified, sir?
Yes, ma'am.
Officer, I want to direct your attention to a case that occurred on July 10th of 2022. Were you working at that time?
Yes.
And were you working as an officer with the police department?
Yes.
Sir, did you have the occasion to respond to 6154 Fieldcrest Road in Morrow, Georgia?
Yes, I believe I did respond.
And is that in Clayton County?
Yes.
What was the reason for your responding to that residence?
We got a disturbance call from Mrs. Derical Hammerter in reference to basically she found a firearm in her household, and that was pretty much it. So we went out to the call. As soon as I got there, I made contact with her. There was a couple kids in the background. There's probably approximately maybe 4. She advised me that basically her kids, they were in the house, they were playing hide and go seek. They found a firearm in the laundry room. She brought that incident up to her husband. I I asked if he can come to the door. She said basically no. I mean, basically he didn't want to come out. A few minutes later, she informed us that he jumped out the bathroom window. We patrolled around the backyard. We weren't able to locate him. She basically told me that basically she's found the firearm. She put it in a plastic bag. She put it in the attic, that the gentleman, Mr. Harris.
Officer, I'm just going to slow you down a bit. I want to ask some very pointed questions. When you responded to that location, who did you say you spoke with initially?
His wife.
And do you know who all resided at that location?
Yeah, from her perspective, the 4 kids, her husband, and herself.
And is her husband, who is her husband?
Mr. Nora Harris.
And do you see Mr. Strike that, Judge. Officer, with respect to the residents at that location, were there any other adult residents at that location based on your knowledge?
No, I went inside the residence. There was no other adults there, no.
And when you spoke with the complainant, did you say her name was Hammerett?
Correct.
When you spoke with Miss Hammerett or Hammerter, what did she inform you was the problem?
Basically that she had basically a verbal altercation with her husband in reference to finding the firearm inside of her household.
And that verbal altercation, what, if anything, occurred during that altercation or was said during that altercation?
What do you mean?
Did she inquire about a firearm that was found in her residence?
Yes, that's the whole reason of the call.
And then who did that firearm belong to?
We believe it belongs to Mr. Nora Harris. He's the one that wanted the firearm back, didn't want her to call the police, and ran out of the incident location when we arrived on scene.
Okay, and how do you know he wanted the firearm back and did not want her to call the police?
I put that in my report because that's what she told me.
Okay, so she told you that he claimed ownership of the firearm and did not want the police called.
Correct.
And after that occurred, did she in fact, after that verbal dispute between herself and the defendant, did she in fact call the police?
She called the police, yes.
And is that when y'all arrived at the residence?
Correct.
And after arriving at the residence, was a firearm at some point handed over to you?
Correct.
And did you ever attempt to make contact with the defendant?
Yes.
Was he at the residence to the best of your knowledge at the time you arrived?
I would believe so, yes. I didn't physically see him, but I believe I probably heard a male's voice in the background, but I can't say that I actually seen him there.
Okay, and were you able to actually make contact with him at that residence on the date of the incident?
No, he fled.
And why not?
Because when I asked for Mr. Harris to come to the door, he was kind of hesitant to come out, and then eventually the wife said that he jumped out of the bathroom window.
And is this the same wife that called the police about the firearm in her home?
Correct.
And is this the same wife that in fact provided you or provided law enforcement with the firearm?
Correct.
Officer, did you have the occasion to run a GCIC or NCIC inquiry about the defendant in this case, Mr. Nora Harris?
Yes.
And what did that investigation or the results of that GCIC or NCIC inquiry uncover?
It showed his criminal history. It showed basically that he was a felon and not have the possession or even be in a household of a firearm.
Thank you, officer. I'm sorry, and just to be clear, did you say that your GCIC or NCIC inquiry showed that he was in fact a convicted felon?
Correct.
Thank you. Nothing further, Judge.
All righty. Mr. Rogers, you can put your hand down, Mr. Harris.
Okay, can I go ahead, John?
Yes, you can.
This Officer Whitworth, let's kind of start at the beginning. Are you the lead officer on this case?
Yes, sir.
And basically everything you said, the whole allegation is all based on the word of Ms. Hamilton, is that correct?
Correct.
And you've referred to her as his wife. Have you seen any sort of proof that she's his wife?
I didn't ask for a marriage certificate. I was going off of which he told me that yes, they're married.
Okay, so just to answer my question, I asked you, have you seen any proof that she is his wife?
No.
And these conversations that we've been discussing, are they recorded?
Yes, on a body cam.
Okay. And let me be a little more specific. Let me clarify. You're referring to the conversation that you had with this person, Ms. Hamilton, correct?
Yeah, and also the whole incident.
When you say the whole incident, what do you mean?
Responding to the incident, doing a patrol around the property to see if we can locate Mr. Harris after he got out the window. So basically that whole call is recorded, yeah.
Okay. And so since you mentioned that video that you were saying about responding to the incident and doing, I guess, kind of a check around, Mr. Harris is not on that video, is that correct? You never saw him that day?
Correct.
And the residence that we're talking about, is this an apartment, a house? What is it?
It's a house.
And what time of day are you all out there?
Let me double check. I don't remember the exact time frame, but I would say it was.
And Judge, the state would object to the officer checking his incident report, just that he testified based on his remembrance of the incident.
Wait, say that again?
I said the state would object to the officer using his report, just that he testified based on his recollection of the incident as it occurred.
Okay, but he can refresh his recollection, right?
Judge, if the defense is asking for him to refresh his recollection, I know there have been some concerns and complaints from defense counsel having issues with officers refreshing their recollection because officers don't have access to those reports at this time in the proceedings. And so the defense counsel has complained that officers should not be able to refresh their recollection with their reports that, in fact, defense counsel does not have access to.
Yeah, I don't recall complaining that they should not be allowed to refresh. I'm not sure if this happened in a different hearing, but I don't recall saying anything like
Okay,
that.
I'm gonna allow him to refresh his recollection.
I would say it's about 1,800 hours.
Thank you, Judge.
So 6 o'clock in the afternoon.
You said about 6 o'clock in the afternoon.
Correct.
And just so I'm clear, so it's still daylight, right? It's July, it's still daylight.
Correct.
Did anybody ever speak with any neighbors, any other witnesses that said they saw Mr. Harris there that day?
No, we didn't speak to any witnesses we didn't speak to any witnesses.
And to kind of go back, because I asked a question, I think it got a little bit confused. When I was asking about questions regarding conversations, I was referring to the conversations that are supposed to happen between Ms. Hamilton and Mr. Harris. Did she provide you with any sort of recording of those conversations?
No, she did not.
And as it relates to her saying that a child found the firearm, did she tell you what child?
She probably did. 2 kids were playing. I don't remember their exact names, but yeah.
Did you speak to either one of those children?
Because they're juveniles, I'm not really supposed to conversate with them. So she can ask the juvenile and, I can hear it, but I'm not really supposed to interrogate a juvenile.
Okay. Well, let's be clear. Nobody's accusing the child of committing a crime, so it wouldn't be an interrogation, would it?
No.
So with that being said, though, as it stands right now, there's no statement from any child saying they found this firearm?
No.
And is there any sort of evidence that he was of the last time? Well, let me ask you, I know you mentioned possibly hearing a male's voice, which says you didn't see anyone, correct?
Can you hear it again?
I said, I think you mentioned possibly hearing a male's voice, but you did not see any adult male at the location?
Correct, yes. I didn't see an adult male.
Were you ever inside of the location?
Yes.
And how many officers were there?
3, I believe. 3 officers.
And this supposed window that was escaped out of, it just opens to the outside? Like it doesn't open to some sort of secret tunnel or anything?
No, it's an actual 2nd floor bathroom window where you can open from either the inside or the outside. Depending if it's locked, you can open it from the outside.
And there's nobody's offered any sort of pictures, videos, any evidence of Mr. Harris ever handling this weapon. Is that correct?
We were presented no video, no. The wife did not record the conversation that took place amongst them two, no.
And were there any kind of steps taken to make sure that she didn't just make up this story? Like, was there anything done to corroborate anything that could be corroborated?
Well, she was advised that basically she did a written statement, basically that any false allegations written down that, she will be penalized for that. Other than that, no.
No further questions. Thank you.
No response, Judge. And the state has no additional witnesses, Judge.
All righty, closing arguments.
State
Ms.
will
Watkins?
reserve.
Okay, all right, Mr. Rogers.
Young, I would be asking the court to dismiss. At this point, we don't have any corroboration of anything relevant to the situation. There's no proof that this woman was his wife. They don't have the same last name. There's nobody showing a marriage license. There's no video. Nobody saying they saw him there. No kids even corroborate the story about finding of the gun. There's nothing to corroborate anything this woman is saying. She could have just as easily said, "It was your gun, Your Honor," and that you was the one that she had the conversation with. Maybe put a felony, well, not necessarily a felony. I'm assuming you don't have any felonies, Your Honor, but that, Your Honor, you would be the person that they could charge if there was an issue with this firearm. That they have the exact same amount of evidence essentially against him as they do against you, and that this is just a story that's being told with they can't even put him on the scene that day. Nobody's saying they saw him in the neighborhood. Apparently he pulled some sort of magic disappearing. I guess he hopped on a magic carpet in the back and flew away. But nobody puts him on the scene. Nobody put a gun in his hand. We don't know who this lady is. She didn't show any kind of proof that she's his wife. She could be a scorn lover with somebody else's gun. And there's nothing to say that there's one way or the other. We have to have some basis to believe her. There's no basis to believe her. It's just a story with a gun. For those reasons, Your Honor, the fact that there is no evidence other than a story made up by somebody who claims to be somebody's wife but has offered no evidence that a child found a gun, but no child has said that they found a gun, and that this man jumped out a back window. Nobody's seen the man on the scene. There's no reason to believe her at this point. So for those reasons, Your Honor, I would ask that the charge be dismissed for lack of probable cause. Thank you.
Judge, at this point, Your Honor, there's no reason to disbelieve the testimony of Officer Whitworth or the testimony as relayed through Officer Whitworth of Ms. Hammerter regarding the reason that law enforcement was in fact called to the scene. In fact, Judge, there are indicias of reliability. There was a 911 call placed. That is the reason why law enforcement arrived at this residence. There was a statement provided that is recorded on body cam of Officer Whitworth and potentially other officers who were on scene. In addition, there was a statement that was written by the victim where she was informed that at the writing of this statement, that anything that she writes down that was untrue, she too could be prosecuted based on that information as testified by Officer Whitworth. So, Judge, there's no reason to disbelieve the testimony. And as Your Honor is well aware that the testimony of a single witness is sufficient to establish a fact, being a requirement at trial, which is a burden that the state is not carrying at this point, Judge. At this point, the state is carrying the burden for probable cause, in that there was in fact probable cause to arrest the defendant in this case for possession of a firearm by a convicted felon. As testified by the officer, he responded to the location because there was a firearm located in the residence. That firearm was located by juveniles who were playing, and that firearm was turned over to their mother, who confronted the defendant, who she states is her husband and resided at that residence, about the firearm, and there was a verbal altercation about that firearm, Judge. And officers did in fact attempt to make contact with the defendant and were unable to do so because they were informed that the defendant exited the residence through a window upon law enforcement's arrival, which would be in alignment with the testimony of Ms. Hammerter that the defendant requested that she not call law enforcement regarding this firearm. And the reason for all of this, Judge, the reason there's an issue that there's a firearm, the reason that the defendant didn't want Ms. Hammerter to call law enforcement, and the reason why he left the residence is because, as Officer Whitworth explained to the court, a GCIC and NCIC inquiry confirmed that he was in fact a convicted felon. And Judge, as charged, OCGA 16-11-131, possession of a firearm by a convicted felon, only requires that a person who is a convicted felon is prohibited from being in possession of a firearm. And in this case, there is testimony of a third party, Ms. Hammerter, that the defendant in fact owned that firearm and possessed it, bringing it into that residence, which was an illegal act and is an illegal act as charged. And as such, Judge, the state is arguing that there is probable cause at this station, at this level in proceeding in the process, and that this case be bound over to Superior Court.
I have one question. When the 911 call was placed, was she just saying somebody in my house got a gun that don't supposed to have one? Did I miss that? What was the purpose of calling 911?
And Judge, I believe this question is directed to Officer Whitworth.
Yes.
Basically, the 911 call was that basically a firearm was found in her house, and basically she doesn't want any firearms in her house. She wants to turn it over to county law enforcement.
Okay. And then is there a relationship between the defendant and the homeowner?
Yes.
What is that relationship?
They're married.
So, okay. And that's what the individual, the victim, said to you, that they were married.
Correct.
Okay. Did you get some identification from her?
Yes, I got her Georgia driver's license.
Okay. And did it appear that they have the same last names? Did they have the same last names?
They did not have the same last names.
Mm-hmm. And did she say where she found the gun at specifically again?
She said that the kids found it in the laundry room, I guess beside the washer and dryer.
And is that the home of Mr. Harris?
Yes, both parties.
All righty. So based upon evidence, yes.
Might I ask some questions to follow up on the court's questions?
You certainly can.
Thank you. How was that established that is Mr. Harris's residence?
Say again?
How was it established that it was Mr. Harris's residence?
Off of let me see, basically his wife's basically informing me, and if I was able to pull up my report when I run the name, I'm not too sure if he came back to that location with his driver's license.
Okay, so basically just based on this person that you keep calling the wife, the one that you never verified the marriage of, is that correct?
Yes, and we technically don't verify marriage certificates on calls.
So just so we're clear, you can't say that he lives there.
If his personal belongings is there, you technically live there in the state of Georgia. You claim residency there. So that right there is good enough to say that he lives there.
So you're saying you spoke with Mr. Harris?
I never said I spoke to Mr. Harris.
Then what did you just say about someone claiming residence?
I'm saying, you're saying, how was I able to prove it? I'm saying if you have your personal belongings there, meaning clothes, and stuff like that, you technically live
I'm
there.
gonna object. I'm gonna object. I said this is non-responsive. My question was, what were you saying about someone claiming residence there?
And Judge, in response to that objection, the officer was responding to Counsel Rogers' question. He stated, the officer stated that based on a person's belongings being at a residence that is claiming residency in the state of Georgia. So it wasn't non-responsive, Judge. It was the officer's response to that counsel's question.
Your Honor, number one, Ms. Watkins does not represent Officer Whitworth, so she can't speak for what he was saying or trying to say. He can answer the question, and that's pretty much how that goes. But she's
That's
not
pretty much what I was saying.
Okay. You have any other questions, Mr. Rogers?
I just want to confirm that you did not verify by speaking to Mr. Harris that he lives there, correct?
Correct.
And you're not testifying that you have any sort of independent record saying that he lives there, correct?
I said if I was able to pull up my report, we run people through GCIC. If it came back to that residence, he lives there. I said I can't pull it up right now.
Yes or no? Are you willing to swear right now that you have information that says Mr. Harris lives there?
No, because I don't have any information.
No further questions.
All right. So based upon the evidence presented, I do find that there is sufficient probable cause to bind this case over to the Superior Court of Clayton County. That's the order of the court.
Okay, Judge, can the officer be excused?
Yes, thanks, officer. And Deputy, if you could bring forward Mr. Callaway, William Callaway. All right, are you Mr. William Callaway?
Yes, ma'am.
Okay. All right, we are about to begin your hearing. Today is August 24th, 2022. I'm Judge Kate Johnson. This is the preliminary hearing for William Ralph Callaway, charged with cruelty to children in the first degree, 2022 CW 53253. Representing the state is Ms. Jocelyn Watkins. Representing the defendant is Mr. Javarik Rogers. Ms. Watkins, your witness.
Thank you, Judge. Good morning, Detective. Please raise your right hand. Do you swear or affirm that the testimony you'll give today in this proceeding will be the truth, the whole truth, and nothing but the truth? Detective, I don't believe I can hear you.
Can you hear me now?
Yes, sir.
Okay.
Would you please introduce yourself? Please, let's do the swearing again one more time, Detective Walker. Would you raise your right hand? Do you swear or affirm that the testimony you'll give today before this court in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Would you please lower your hand and introduce yourself to the judge and opposing counsel?
Detective A. Walker with Clayton County Police Department.
And Detective Walker, how long have you been employed with the Clayton County Police Department?
8 years.
And what are your duties?
I work with crimes against children in the Criminal Investigative Division.
And with respect to the Crimes Against Children unit, what kinds of crimes do you handle?
Molestations, any types of physical assaults, anything that's dealing with children.
And how long have you been in that unit?
Almost 2 years.
And in that 2-year time span, approximately how many cases have you handled?
I can't give you an accurate number, but there's been several.
And do you have any particular training or experience with respect to handling these types of cases?
I've had interviews and interrogations. I've had search warrants training at Gypstick. hold on one second. I'm sorry.
Thank you, Detective Walker. Prior to being in this unit, were you in another unit with the Clayton County Police Department?
Uniform patrol.
And on uniform patrol, did you have occasion to respond to cases that might also involve children?
I did.
And how long were you on patrol with the Clayton County Police Department?
6 years.
And in that 6-year time span, do you know about how many cases with respect to this general crimes against children nature that you handled in that capacity?
I can't give you an accurate number, but several.
I want to direct your attention to the incident that occurred on June 14th, 2022. Were you working with the Clayton County Police Department on June 14th, 2022?
Yes.
And in what capacity were you working at that time?
NCID.
And Detective Walker, at that time, were you post-certified?
Yes.
And have you maintained an active post-certification during your entire employment with the Clayton County Police Department?
Yes.
Detective, have you had the occasion to become involved with a case involving a juvenile, Miss Aaliyah Calloway?
Yes.
And can you explain to the court what your involvement with that case was?
Well, we got got a report in reference to a child having some bleeding on the brain and behind the eyes. So I began the investigation. I contacted the social worker, Lydia Seawright, and she reaffirmed what was stated in the report. I talked with the mother of the juvenile. The mother stated that there was an incident that involved her daughter, but she did not know that the police was involved because it was actually the social worker who actually made the report. So she made mention that she was on the phone with Mr. Calloway when the incident took place. She was not there. I got in contact with Eggleston Hospital and received medical records. I also spoke with one of the staff members there, and they reaffirmed that there was a situation with the child that is consistent with non-accidental injuries. I also went out to the home and measured the bed because the allegation is the child just fell off the bed.
I'm going to object to it. I would say at this point it's become either non-responsive or the question.
Here.
All right, so Ms. Watkins, make sure you're asking Mr. Walker questions and he's not just narrating. Mr. Walker, only respond to the question that Ms. Watkins asked you, okay?
Okay.
All right.
Thank you, Judge. Detective Walker, focusing specifically on the incident that occurred on June 14th, 2022, was that residence that you were referencing a moment ago, 746 Garden Walk Boulevard, Building E, Apartment 14 in College Park, Georgia?
Yes.
And is that here in Clayton County?
Yes.
And you stated that you spoke with the complainant in this case, a social worker. Was that person a woman by the name of Miss Lydia Seawright?
Yes.
And did Ms. Seawright inform you that she came to believe that a child, the victim in this?
This is a leading question. I was saying it's a leading question, Your Honor. I'm objecting.
And so Ms. Watkins, just restate.
Yes, Judge, thank you. Detective, what did Miss Lydia Seawright inform you?
That the child received some injuries in terms of blunt trauma to the head.
And was the child taken to receive any medical attention based on those injuries that she sustained?
Yes.
And where was that child taken for that medical treatment?
Eggleston Hospital.
And at Eggleston Hospital, was the child in fact seen regarding those injuries that were sustained?
Yes.
And did the doctors at that time determine that it had something to do with blunt trauma?
Yes.
Ultimately, were there additional examinations performed in addition to general observations of the child? Were there any other scans or x-rays conducted?
Yes,
And what was that?
a CT was done.
And from that CT, were there medical records, were there findings determined by the medical professionals?
Yes,
And did those findings show that there was substantial, there was a subdural hematoma bilaterally?
And it's a leading question. It's another leading question, and I would object.
Okay, Ms. Walker, you can't suggest the answer in your question. Keep going. Go ahead.
Thank you, Judge. What else did the medical records suggest, Detective Walker?
It stated that the final diagnosis was non-accidental trauma to the head.
And was that based on both the head CT scan that was performed and any other observations done by those medical professionals?
Yes.
Detective, was it, did you also go out to the scene to look at the location where the child sustained the injuries?
Yes.
And were you given any information about how that child potentially sustained those injuries?
I actually went to the scene and measured the bed from the floor to the top of the bed.
And prior to your measuring the bed, did you have any indication of what was being told either to law enforcement or medical professionals about how the child sustained those injuries?
According to the medical records, it was told to the medical staff that the child only fell from 3 to 4 feet from the top of the bed. But once I measured it, it was only 2 feet by 5 inches when I measured the bed. And there was also carpet on the floor.
And did you make any other observations of the bed or the room where that child may have sustained those injuries?
I did.
And what were those observations?
The bed itself, it had like a dip in the middle. And the top of the bottom of the bed was kind of like elevated. So it was kind of like a slope.
And so did you make any observations of the flooring where that bed was located?
Revise?
Of the floor, was it carpeted or not carpeted?
It was carpeted.
And Detective, based on those observations and the information you received from the medical finding, did you find that to be consistent with the information in the medical records?
I did.
And based on the medical records, were there any additional findings provided by medical professionals about the injuries sustained by the victim, Ms. Calloway?
There was.
And what were those findings?
Left to the right vertex, subdural collections that included acute hemorrhaging to the head. There was also a bilateral interretinal and pre-retinal hemorrhaging, which is consistent with non-accidental trauma. They also stated in the medical record that the degree of hemorrhaging is out of proportion.
Yeah, and I'm going next here. It appears the witness is just reading right now. So
Okay.
if that.
Yes, I agree. Mr. Walker, Officer Walker, just again respond to Ms. Watkins' questions only. You were about to go into something additional.
Well, I'm not a medical professional, so I can only state the medical terms.
That's fine. That's fine.
I mean, I can only do what I can when it comes to that medical portion.
That's fine. Go ahead, Ms. Watkins.
Thank you. Detective Walker, ultimately, did the medical findings find that this was an accidental injury to the child?
No.
And did they find that the injuries to be consistent or inconsistent with a fall from the height of the bed as you measured it in the bedroom where the child was alleged to have fallen?
It was inconsistent according to what was stated to them.
Thank you, Detective Walker. Nothing further, Your Honor.
All righty, Mr. Rogers.
Thank you. Detective Walker, I guess we can start kind of towards the end, just about that last question. First, I want to make sure I heard it correctly. You said that medical professionals told you that? Is that what you said?
The medical records.
Okay, medical records. Do you know who, as far as the source of those records, like what kind of medical professional generated the records?
The medical staff at Eggleston Hospital.
Have you spoken to anybody as far as medical staff Eggleston?
No. I mean, I did speak to, I'm sorry, turn around. I did speak with Miss Bethany Fuggle. She's the licensed medical social worker there.
And just so I want to make sure I don't want to butcher her name. You said Bethany. What was the last name?
I can spell it. Can I spell it?
That's fine. Yeah,
Okay. Feggadel. Fuggle. She's the LMSA. I'm sorry, go ahead.
I wasn't trying to cut you off. Feggadel.
Bethany is the first name. Feggadel.
Okay. All right. Well, in the interest of not butchering her name, Miss F. Who is she exactly?
She's the cardiac services licensed medical social worker.
And I don't know if you know or not, but to me, it does not sound like she performs medical examinations and things. It seems kind of that she does the social work aspect of it. Is that your understanding?
Well, you asked me, did I speak to anyone at the hospital? That's
Right,
who I
no.
spoke to.
Yeah, I'm asking about, do you know whether or not she is actually involved in medical procedures? Do you know anything about her role is what I'm asking?
No.
And I kind of asked you two questions just then. Do you know whether or not she is involved in medical procedures?
I don't know.
Okay. And Detective, presumably you're the lead on this case, is that correct?
Yes, sir.
And you had a chance to review at this point all of the records and generated either by medical professionals or law enforcement. Is that fair to say?
Repeat that question again.
I said, as the lead, you've had an opportunity to review records both from medical professionals and law enforcement. Is that fair to say?
Yes, sir.
And as it stands right now regarding the incident, do you know the date of the alleged incident?
June the 11th.
How was that date established?
This is when the social worker called the report in, because the mother took the child to the hospital.
On the 11th?
On the 11th, yes.
And I know you said that you had spoken to the mother and that she was on the phone during the incident. To your knowledge, is there anybody present at the time of the alleged incident?
To my knowledge, the only person that was present is the father.
And has there ever, well, let me ask this, I guess, besides the conversation where the mother told you that she was on the phone and she wasn't present, what was the context of that conversation? Were you all in person? What was the context of that conversation?
Just asking her what happened.
Okay. Was this on scene? Were you all in person, the two of you?
No, it was initially just over the phone.
Is that conversation recorded in any kind of way as far as audio or anything?
It was not recorded.
And at this point, have you ever spoken to Mr. Calloway about the situation?
I did.
And as far as you know, well, let me ask it this way. Have you ever asked about whether or not anyone else would have had custody of the child at any points leading up, we'll say 48 hours leading up to the admission to the hospital?
I don't recall asking him that question.
And as far as the records and reports you got from the hospital, were they able to tell you approximately when the injury would have occurred, or to give you some sort of time frame?
I didn't ask that question.
I know you said you responded to the scene and took some measurements. Other than taking measurements, was any sort of evidence or anything collected from the scene?
No, sir, I didn't collect anything.
And when you went to take the measurements and everything, is that part videotaped and everything?
I took photos. Oh, another detective took photos while I actually did the measurement myself.
And you were saying something about, and I was unclear about a slope of some sort, I thought.
I'm sorry, did you want me to answer that?
Well, yeah, well, first let me ask, what were we talking about? Like, is the slope in the mattress, the frame? Like, what are you, when you're saying there's
There was
a
like a dip in the bed.
Okay.
Like the queen size bed itself, the bed is typically straight, right?
Right.
So in the middle of the bed, there was like a little dip, like a little indention of the bed.
Mm.
But at the floor, the floor of the bed, it was elevated.
Okay.
So
there's kind of there's a downward slope. If you're on the top of the bed, there's a downward slope.
There's a dip in the middle of the bed.
Like a valley, not so much a downhill, but kind of a valley in the middle of the bed. Is that what you're saying?
Trying to see
Let me ask you like this. There's two ways it could go. It could be a completely constantly downhill sloping thing, or it can be kind of a valley. Like it can kind of.
Yes.
And that's what you're saying. Okay. Yes. And then you're saying below that area, or the bed itself is raised. What are you saying is raised?
The foot of the bed, it was somewhat elevated a little bit.
So let me ask this, is it level?
The bed itself?
Right.
Not completely straight.
And then the measurements you were talking about taking, where did you take the measurements from? Like
the floor of the bed to the bottom of the mattress. The foot of the mattress.
I think I'm a little bit confused. You took the measurement from the floor.
The floor, the carpeted floor to the foot of the mattress.
When we say the foot, you mean the top side of the mattress?
Yes.
And did you take them at both the dip part and the non-dip parts of the?
No, no, sir.
So the measurement that you gave us about 2.5 feet, that's from the floor to the dip section?
That's from the floor to the elevated foot of the mattress.
And I know you may or may not recall, but to your knowledge, I don't recall seeing any mention of any broken skin or anything like that.
A broken what?
Broken skin or anything like that. Was there, to your knowledge, was there any mention of broken skin or anything?
No, sir.
And let me ask, when you spoke to Mr. Calloway, that was because he came to the precinct voluntarily, is that correct?
Yes, he did.
And that conversation, was it recorded?
Yes, it was.
Was there already a warrant out for him at that time?
No, sir.
And at that point, when you spoke to Mr. Calloway, had you already spoken to Bethany F. and the mother of the child at that point?
Yeah, Mr. Calloway was my last person I spoke to.
I'm sorry, you kind of broke up a little bit.
Mr. Calloway was the last person that I spoke to.
Okay, I just want to make sure I heard you because I think the string came through a little bit patchy. You said he was the last person you spoke to?
Yes.
So, and just, I don't want to assume too much or be unclear about things, but you had already received the information regarding the suspicion of non-accidental trauma from Eggleston.
Yes.
Was he Mirandized before the conversation?
Yes.
And to your knowledge, has there been any I guess revisions or changes about what the medical professionals have to say about their theories about the case?
Not to my knowledge.
No further questions at this time.
All right, Ms. Watkins, any redirect?
Just briefly, Judge. Detective Walker, do you know the defendant's relationship to the victim in this case?
I'm sorry, repeat the question.
Do you know the defendant's relationship to the victim in this case?
Biological father.
Thank you. Nothing further, Judge.
All righty. Any closing arguments? Ms. Watkins?
Yes, Judge, the state will reserve and go last.
All right, Mr. Rogers.
Thank you, Your Honor. At this point, I would ask that Your Honor would dismiss the charge for lack of probable cause. Specifically, the fact that we don't know a few things that are kind of essential to even beginning to assign blame. And what I mean is that at this point, we don't have a time frame or a window when the injury was inflicted that led to the manifestation of the injury. There's not anybody who's saying that they saw Mr. Calloway do anything untoward towards the child that would have inflicted such an injury. The detective's investigation or inspection of the area, it at least revealed that the bed isn't level, which, you know, as somebody, I could tell you a story about being on an unlevel bed and how I ended up in the hospital, at least in part because the bed was not level. But in any event, I would say that it's a little premature to be charging him if we can't say that the injury happened, for example, on Monday between noon and 8 p.m. and that the child was with Mr. Calloway between noon and 8 p.m., then I don't know how we're going to accuse Mr. Calloway of being the person who inflicted relevant injuries. Additionally, like I said, there's nobody else implicating him as the person who inflicted the injuries. There's just no basis at this point to charge him without at least some time frame of when the injuries occurred and who had custody of the child. Those seem to be the two main questions you would need to know before you accuse somebody of injuring a child. Because there are times when people are injured and the manifestation of the injury doesn't occur right away or for a few days. And so for those reasons, Your Honor, until we have information about those kinds of things, I think it's premature, and I would ask you to dismiss. Thank you.
All righty. Ms. Watkins?
Thank you, Judge. Your Honor, at this time, the state wants just to remind the court that at the preliminary hearing, we're only looking at whether there is enough probable cause that the defendant, in this case, is likely to have committed, or that there's probable cause that he committed the crimes as alleged, or the crime in this case is one count of cruelty to children in the first degree. And with that in mind, Judge, I just want to briefly talk to the credibility of Detective Walker and the testimony as it came out in court today. Detective Walker testified that he was a part of the investigation after an outcry from a social worker at Eggleston Hospital because the victim, Miss Aaliyah Calloway, was taken for injuries that she sustained as were alleged by her falling off of the bed. And Judge, that allegation and how those injuries were sustained, as Detective Walker testified, came from Miss Calloway's mother, who took her to the hospital and who was informed by the defendant of the type of injuries because Miss Calloway's mother, in fact, was not at the residence at the time that the injuries occurred. And so at the time that Ms. Calloway, the victim, was taken to the hospital, additional examinations and CT scans were conducted that showed that there were substantial injuries to the victim, including bilateral hematomas, and that there was blood behind the victim's eyes. The detective did not present himself as a medical expert stating that he had conducted any of these tests, but just that this is what the medical records found with respect to her injuries. There were no inflations of testimony and no allegations that there were any broken bones or that there were any cuts or bruises or bleeding to the child as questioned by opposing counsel, only that the medical findings based on the CT scan found that those injuries were subflesh, subdural hematomas, and things of that nature based on what was alleged to have been a fall from the bed in the residence where the defendant was in the custody of the child at the time that it is alleged that she sustained these injuries. And when we look at the physical evidence, Your Honor, the residence and the bedroom and the bed where the injuries were where the injuries were alleged to have been sustained, the testimony is clear that the injuries could not have been sustained from a fall from that bed. The medical professionals were informed that the bed may have been 3 to 4 feet off of the ground based on the estimation given by the victim's mother at the time she took her to the hospital. And the medical professionals conducted their examinations and determined that it could not have been a 3 to even 4 foot fall that caused those types of injuries, let alone the fact that when Detective Walker did his examination and in fact measured the height of the bed, it was found to only be at 2 feet and 5 inches. And so if the injuries could not have been sustained at 3 to 4 feet, they definitely couldn't have been sustained at 2.5 feet off the ground. And so when we look at the fact that there were injuries of that nature and the height of the bed is only 2 feet 5 inches off the ground, even taking into consideration that there was a dip in the bed and that the bed was on a carpeted flooring in the residence, again, all of that supports the findings of the medical professionals that those injuries could not have been sustained accidentally and were in fact not sustained in the manner that had been stated to medical professionals. And so, Your Honor, if we look to what the code requires for a charge of cruelty to children in the first degree, OCGA 16570, Section B, which is the actual subsection that the defendant is charged with, a person commits the offense of cruelty to children in the first degree when they maliciously cause a child under the age of 18 cruel or excessive physical pain, or physical or mental pain. And in this case, Judge, the child was under the age of 18, as indicated by the involvement of social workers in this case for a juvenile being taken to the hospital. It was alleged that the juvenile rolled or fell off of the bed, and it was determined that that could not have been accidental and that those injuries were in fact not accidental. And the state would put to the court that the testimony at this point, as given by Detective Walker through the medical professionals and the victim's mother who took her to the hospital and the social workers who were involved in this case, is that this was not in fact an accidental injury to the child. It was in fact a malicious injury, and that the only person who was in the custody, that the only person who had custody of the child at the time that these injuries were sustained was in fact the defendant. And as such, Judge, the state believes that there is probable cause for this case to move forward and would ask that Your Honor bind this case over to Superior Court.
All right, so based upon the evidence presented here today, I do find there's sufficient probable cause to bind this case over to the Superior Court, Clayton County. That's the order of the court.
Thank you, Judge.
All right.
May Detective Walker be excused.
Yes, thank you, Detective.